Your Lord, that series will not, your Lordship, last order has yielded result. They have ultimately filed a reply, but we may have to file a short reply. Therefore, may I just pray that let it be heard after the due subject to your Lordship's conviction.
Matters are listed in the supplementary list.
Yes, supplementary 61 to 76. Two other matters were left out. We will give the numbers. They can maybe also check with me.
61 to
61 to 76.
76. Mr. P.K. Goswami, the learned senior counsel, assisted by well, who appeared? Mr. P.N. Sharma. It is elementary.
Secondary, I think.
Secondary, no? Mr. P.N. Sharma appears on behalf of the Secondary Education Department. It has been brought to the notice of this court that the affidavit in opposition has been filed by the Secondary Education Department. The learned counsel for the petitioner, the learned senior counsel for the petitioner submits that some accommodation be granted to the petitioners for filing a reply. Accordingly, let the matter, yes, when can we fix it?
After the revision, whatever.
Any date? We'll have it on 20. The matter be listed on 24/2023. In the meantime, the petitioner, if so advised, is at liberty to file the reply.
And two other matters will give the numbers. They can also be checked with me. We'll give this.
Mr. P.K. Goswami, the learned senior counsel for the submit, that along with the series of the matters, there are two other connected with petitions, being WPC number so and so and so and so. And the same may also be tagged along with the current batch of writ petitions. In that view of the matter, the registry is directed to tag along the WPC number so and so and so and so along with the current batch on and list as above.
May I begin? When I check to mention item number 77, my lord.
Okay.
Yesterday, my lord, I made the mention your lordship, my lord, directed me to my lord.
Take it out.
For upgradation, my lord.
My lord, I beg to make a small prayer, my lord. Item 53, my lord. May it kindly be taken at 2, my lord.
Why?
Because before 1 minute it may not reach, and I shall have to go to prayer, my master. Or in some other day, man. It is French.
Mr. Counsel, the problem is, I have no problem in granting upgradation, but what I find out later on, there are a lot of counsels who makes prayers for upgradation, and then I see that the matter is not fixed for instructions or anything. They just upgrade it. That is the problem, and at the end of the day, the other matters which are to be taken up are being not taken up.
So may I pray, my lord, the matter may can be taken some other day, other than Friday.
Okay. Item number 52.
54, my.
54. At the request of Mr. M.H. Rajbhaiya, the learned counsel for the petitioner, let the matter be listed on 26th April.
May please, your lordship. Item number 53 of my lord Justice Shams Suman Shams list. For that,
there is only one list.
no, not before your lordship. My lord Justice Sham is not sitting today in a single bench.
I don't have that list.
That was the notification that urgent matters to be mentioned before your lordship. Accordingly, my lord, the interim protection is still today. I've informed all the counsel. Mr. R. Dubey is there. Mr. R. Goswami is there. I've informed them. So may I pray the matter be taken up? 53. 53.
Not my list.
This was the matter when lordship had heard the matter for the interim order earlier.
May I please? Same thing for listing this matter for motion today itself.
Today?
Lordship.
Why?
Because the computer proficiency test will be held on coming Monday, Lordship. in the advertisement, this is regarding recruitment to Departmental in the Nalpati district, Lordship. Obliged, Lordship.
So may I pray for listing the matter I will file today. I pray for listing.
Listing, which matter?
Also on the other day, the matter I withdraw with the
We
liberty.
have filed a petition.
File.
Okay, you want it to be taken up today at 2? Yeah, is it a new matter?
New matter, Lordship. Regarding
I understand that matter.
That
It's suspension of the Qazi.
suspension.
Okay, leave it at 2.
Obliged.
I think matter for listing on the Tuesday, Lordship. Listing for Tuesday, Lordship.
Tuesday,
Tuesday for motion.
for motion.
Because matter was already listed in court number 5 part to the debate.
Huh?
So this matter was listed today in court number 5 part is the debate. So I mentioned for Tuesday, Lordship.
It's already listed.
Today listed, but it was debate for it was listed as a sponsor
So you want it on Tuesday. It's a motion matter.
motion.
Why Tuesday? What is so nice about Tuesday?
What's this item?
Huh?
Item.
Urgency. So not, why not on Monday?
It would permit them.
Oh, why should I give you on a
Yes, Monday.
non-miscellaneous day? Okay, Monday.
Item number 52, we have filed an affidavit yesterday.
Item number
52,
52.
yesterday
Yes.
call for lodging.
Please, your lordship. I beg to mention item number 2 and 3 of court number 5. Now, when the justice human term is not sitting today. This matter may be today.
What do you want,
Matter related to contempt,
Mr. Counsel? What do you want
this matter may be taken up today
today?
or Monday.
Monday?
Is your lordship. Lordship, I pray for listing of the contempt case matter. Lordship, in this matter, my
Contempt matter?
lordship, any date before vacation, my lord, the petitioner is
But
suffering from.
madam, as per the roster, isn't the contempt before the Chief Justice?
This is my lord bench 3 matter, my lord. It's supposed to come before the bench 3 contempt matter. Sir.
You mention it on Monday. There's no urgency out there.
Please, your lordship. Your lordship, in item number 60, we have filed an affidavit today, your lordship. Same may be called. If you
Please, your lordship. Lordship, I beg to mention item number 25 to 33, Lord.
25.
25 to 33, Lord.
Yes, what is that?
Lordship, we are being led by Dr. Saraf in this case, Lord. The lordship may not like to take up.
Okay, 25 to 33. It has been submitted by the learned counsel appearing on behalf of the petitioner. That in these matters, Dr. Saraf would be leading them, taking into account that this court does not take up matters pertaining wherein Dr. Saraf appears, Ashok Saraf appears. Let these matters be listed before any other bench.
Highly observed.
It is a lordship. May I pray for an updatation of item number 52, lordship.
52,
Lordship.
yes.
Lordship, on the last occasion, lordship, I asked the departmental councils to produce instructions, which they have done so when
Okay,
it will
52.
call for it.
Agreed. Yes, let us have the matter.
Delhi list item number 1 from Ozone.
It is the lordship. This matter, my lord, we want to withdraw this petition, my lord,
Okay,
and my lord, liberty to file before the appropriate forum.
second one, I mean, second wife.
Yes, my.
What liberty?
To approach before the appropriate forum, my lord, civil court.
Miss
RS Deori, my.
R.A. Theory, the learned counsel for the petitioner. And madam, you are appearing for which department?
Irrigation Department 136 and 136 and
1, 3, and 6. And Mr. B. Chakraborty appears for the Accountant
Four
General.
and five, Lordship.
That's one number 5. And you are appearing for somebody?
I am only appearing for 1 and 3, Your Lord.
One.
He is appearing for 3.
The learned counsel for the petitioner submits that she doesn't want to press the instant writ petition. Taking into account the instant petition stands dismissed on withdrawal. It is made clear that the dismissal of the writ petition on withdrawal shall not preclude the petitioner to avail such remedies otherwise available under law.
Item number 2.
Yeah, please. So here the petitioner is family pensioner, Lordship. Petitioner is family pensioner, Lordship. His husband died in 1994 in harness, Lordship. During the service period of the husband, Lordship, he was allowed to draw extended scale of payment, Lordship, with effect from 1/1/1982 and revised scale, Lordship, from 1/1/1989. After his death, Lordship, during the process of pension, family pension, Lordship, this Lordship extended scale and revised scale was withdrawn, Lordship, from him, and certain amount was recovered from the family pension of the family petitioner, Lordship. Then, Lordship, is that similarly situated the person's, Lordship, approached before this honorable court, Lordship, and this court was very short order, page number 26.
Yes, your name.
PK, that's right.
And so the learned counsel appears on behalf of the petitioner. Madam, you are appearing for?
Secondary Department, my Lord.
What is that secondary?
Education.
Okay.
For 1, 2, 3, my Lord.
1. Your name?
H. Deranki, my Lord.
And so appears on behalf of the respondent number 1, 2, 3, and Mr.
1,
S.R.
2, 3,
Burua
well.
appears for respondent number 4. Issue notice making it returnable by 4 weeks. As the respondents are duly represented, extra copies of the writ petition be furnished to the learned counsels within 3 days. The case of the petitioner herein is in short that the husband of the petitioner was receiving a particular pay scale. Upon the death of the husband of the petitioner, her husband duly received the pension. You got a pension?
Lordship, family pension
Your husband?
not died in harness, Lordship.
Oh. Was it is the case of the petitioner that the husband of the petitioner died in harness on
15/12/1994.
18/12/1984.
15
15/12/1980.
1994.
1994. Subsequent thereto, the petitioner have been paid the family pension. However, there were certain deductions made to the family pension of the petitioner to the tune of rupees 43,718. As well as the petitioner now has been given the family pension without taking into account the extended scale of pay allowed to the husband. The respondent on behalf of the counsels on behalf of the respondents on the next date shall apprise this court by way of instructions and or affidavit as to why the petitioner is not entitled to the reliefs as sought for in the writ petition.
Lordship, pendency of the writ petition may not part if a respondent
Why have you come there?
during pendency the
Don't make.
obliged.
Item number 3.
itu eta কাম কৰক, issue notice making it returnable on 8th of May, huh? 8th of May. Yes, Mr. Hawk.
My lord, here in this case, my lord, after filing of the petition, my lord, the recently, my lord, the Deputy Commissioner of Police had intimated the petitioner that the departmental proceeding has already been completed, my lord.
Very well. Now what was the prayer?
Ultimately, my lord, it will be infectious, my lord.
Huh?
Yes, my lord, departmental proceeding. My prayer was that, my lord, departmental proceeding, my lord.
Lord Mr. S. Hawk, the learned counsel appearing on behalf of the petitioner, Mr. D. Bora appears for the state respondents. Full stop. The learned counsel for the petitioner had submits that the instant writ petition has been filed challenging the departmental proceedings initiated against the petition. However, the petitioner have recently been informed
Yeah.
after filing of the writ petition that the departmental proceedings is already over. Under such circumstances, the learned counsel for the petitioner submits that the instant writ petition has become infructuous. Full stop. He, however, submits that infructuous for which he seeks the liberty to withdraw the instant writ petition. The learned counsel, however, submits that the withdrawal of the writ petition shall not preclude the rights of the petitioner to challenge the disciplinary proceedings, the departmental proceedings, as well as the actions taken by the disciplinary authority in pursuance thereto. If the petitioner is aggrieved. Taking into account, they say submission, the instant petition stands dismissed on withdrawal. However, it is made clear that in the circumstance the petitioner is aggrieved by any actions taken by the disciplinary authority, the same shall constitute a separate and the same shall constitute a cause of action, which is separate and distinct from the instant proceedings. And as such, the petitioner, it shall not preclude the petitioner to challenge the same if so permissible under law.
Item 4.
Yes.
My lord, he was initially appointed in 1987. My lord, while he was serving in a particular school, my lord.
Area salary
My lord,
from 2007 to 2016
about 9.
for
9
his
years.
survival without any further delay, in as much as the gap period has already been regularized by an extra 6. This is suspension.
No, my lord. My lord, what happened, my lord? While he was serving, my lord, in 2007, there was a fatal killing in Goro community in Kopraza district. Lot of employee, lot of personnel killed by each other group, my lord. Lot of person and employees were killed, my lord. Even petitioner's own brother was killed.
Own brother was
Killed by
killed.
my lord. That is killing, my lord. My lord, the petitioner himself is concealed for a gap period, for a particular period. He could not attend in the service. Lastly, my lord, in 2016, he came forward. And again, he filed an application before the respondent, my lord. His service was reinstated. And my lord, salary was paid for.
Just 1 minute. Yes, tell me.
While he, my lord, came forward in 2016, his service was reinstated. And accordingly,
The service was reinstated.
Yes, page, my lord, you lordship kindly see annexure 5 page. Annexure 5 page 20, my lord. Page 21 and 22 also kindly be.
Now, what do you want?
My lord, only my lord, I am retiring on first week of April, this April, my lord. Now, my lord, during gaps period, my lord, now, my lord, I may be considered for salary, my lord. In fact, my lord, I am,
Why have you woken up so late?
I don't think that is the problem, my lord.
Understood. Let us assume you 2007 to 2016, it is okay. You have been reinstated. But after 2016,
My lord.
why after 7
My
years?
lord, yes, my lord, that is the problem, but that may be considered, my lord.
Hmm?
That may be considered.
Have you submitted any
Yes, my lord,
representation?
I have submitted annexure, my lord, details, and my lord, annexure.
What is the date of the representation?
Representation, my lord,
13/7,
2017.
2017. Then
7,
we are in 2023.
my lord, 23.
Then why should this court at all entertain your petition?
I think, my lord, since my lord, his service has been regularized subsequent
That was in 2016.
2016, my lord.
But how do you explain after 2017? Tell me.
My lord, that is in fact late some.
Huh?
Some late has been caused. My lord. Only, my lord, my representation may be considered, my lord. Authority will take decision since my service has been regularized and reinstated. No departmental proceeding has been initiated. Only, my lord, it shall be, my lord, directed to consider my gap period.
Okay, I dismiss your petition with a direction to reconsider your representation. That is the only way I can do.
May not be dismissed, may not only consider.
Yes, heard Mr. A. Manaf, the learned counsel appearing on behalf of the petitioner. Who appears for others? No PTC. Oh, PTC, you are there, Mr. Chaudhary. Mr. Elementary, Mr. P.N. Sharma appears on behalf of the respondent number 1. Mr. R. Purpuzari appears for the respondent number 2. Mr. B. Chaudhary appears for the respondent number 3, 4, and 5. Stop. The instant matter is taken up for disposal at the motion stage itself. The case of the petitioner herein is that the petitioner was appointed as while serving as well
Hindi teacher.
huh?
Hindi teacher.
Hindi teacher while serving in Solakoti ME School, Pokraja in the year 2007. Due to the prevailing situation then, and also taking into account that he was targeted the petitioner and his family member concealed themselves in some unknown place for saving their lives. This aspect of the matter was informed to the headmaster of Solakoti ME School by forwarding an application dated 13/8/2007. After thereafter, when the situation normalized sometime in the year 2016, the petitioner came forward and joined the school. It reveals from the order dated 18/10/2016 issued by the Secretary of Boroland Territorial Council, whereby there was an approval given by the Procedural Territorial Council for reinstatement of the petitioner to the service with immediate effect, subject to initiating departmental proceedings. It further appears that on the same day, the District Elementary Education Officer, Kokrajhar, had also passed an order whereby the services of the petitioner was reinstated and posted at Bonargaon ME School, Bonargaon, as
Bonargaon.
Hindi teacher. It was mentioned that for pensionary purpose, the gap period can be regularized for pension benefit. Subsequent thereto, subsequently on the next day itself, the District Elementary Education Officer in partial modification to the order dated 18/11/2016, regularized the period from 4/7/2007 to 17/11/2016 for only for pensionary benefit. Thereupon, on 13/7/2017, the petitioner requested for release of the arrear amount of salary for the period from 4/5/2007 to 20/11/2017 by submitting a representation to the District Elementary Education Officer, Kokrajhar. However, nothing has been done thereafter, for which the petitioner has approached this court. I have perused the writ petition, and there seems to be nothing mentioned as explaining the delay and latches on the part of the petition in approaching this court almost after 6.5 years. Consequently, this court is not inclined to exercise its extraordinary jurisdiction to pass to issue writ in respect to the relief sought for by the petition. However, this court is also of the opinion. However, this court also observed that the dismissal of the writ petition by this court, having been done on the technical ground of delay and laches, the same shall not preclude the District Elementary Education Officer, Kokrajhar, to consider the representation dated 13/7/2017 submitted to the said official in a manner provided in the law. I gave you that. I can't give you more than that. Oh, mosquito.
5.
Yes, Mr. Talukar.
May I please allow? My lord, here is a suspension order, my lord, which I am challenging on 2 grounds. Firstly, my lord, the suspension order has been given a retrospective effect. Now, of the period for which, my lord, he has rendered service, that period cannot be obliterated by the authorities, number 1. Number 2, for that period, he has already, my lord, he obtained a salary. Now, my lord, nothing can be, my lord, deducted corresponding, my lord, to subsistence allowance. So, my lord, on that count, the suspension order is bad, because under the rules also, there is no provision, my lord, for a retrospective operation of suspension order. And I'll place a Calcutta High Court judgment, division bench, my lord, which says it is not permissible in absence, my lord, of the express provision. Secondly, my lord, the suspension order is bad on the ground that the currency, my lord, has been allowed to, my lord, allowed beyond, my lord, 90 days without, my lord, submission of, my lord, charge memo in terms of other Chaudhary's case. Now, what has happened, my lord? He was arrested on 26/8 by operation of law, my lord, having
Let
been
us see where. When were you arrested?
My lord,
Let
on
us see the
20
suspension order.
Yes, I take your lordships to the suspension order at page, my lord, 31.
Page 30.
Yes, my lord, 29th of October
It
22.
is expedient on behalf. So, what is wrong?
Well, nothing wrong. Your lordship will kindly see. My lord,
Did the Calcutta High Court dealing with it dealt with a similar provision like 6.2, which dates back to the date of suspension?
no, I'm coming to that, my lord. What has happened, my lord, after his arrest on 26/8, my lord, he was released on, my lord, bail on 28/9/22.
28,
9/22.
9/22.
Yes. Thereafter, my lord, he joined the service on 30/9/22. The joining report is there, my lord. He has been allowed to join at page 28, my lord.
Mr. Taluga, have you looked into the judgment in the case of Rajiv? What is that judgment? There the question involved therein was this. The person concerned was arrested. He was released on bail. Thereafter, the authority suspended him from then. And the question involved therein, the specific question was that once he has already been released, can you still invoke the same power for suspension? The Supreme Court said yes.
My lord, here my respectful submission is
That I should follow Calcutta High Court.
no, my lord, lordship, my lord, may not go Calcutta High Court. My lord, having been released on 28/9/22, he joined on 39.
Understood, the same
lordship,
thing.
kindly allow my lord me submit. He joined, my. So the moment, my lord, he has been allowed to join, my lord, the suspension, the deemed suspension under Rule 6, my lord, has to be understood to be, my lord, cancelled. There is a deemed cancellation of the suspension order by operation of law which took place, my lord.
No,
Because your lordship
won't. Because your suspension, because you see the language of 6.2,
Yes.
it categorically says the person after completion of 48 hours in custody, he should be deemed to be suspended
lord.
from the date on which he had been suspended, arrested.
Yes,
So he goes
Yes.
back to that push.
exactly, my lord.
Yeah.
I am on there.
Yeah.
My lord, my suspension goes back, my lord, to the date of my arrest. My lord, I'm not disputing on that. What I am on, the moment you have allowed me to join, there is a deemed cancellation of my suspension
No,
order.
it won't be. Because then you come to 6.5. 6.5 says that there has to be an order. See,
Correct.
Well,
Now, your lord,
unless you come within the proviso to that effect, which is given in 6.2. You see the judgment, but let us not go. You may look into it on a finer point later on, but you are now concerned with 3 months being over.
yes, yes. Ajay Chaudhary, ma'am.
We have to take instructions on.
Yeah.
But you see the judgment.
My lord, definitely.
Because I have dealt with that judgment in the case of our law. But what the difference with of that judgment with the present judgment, I mean, with our rules, is that that was done under the CCS 65 rules. And there is a provision that is 10.5.3, 10.5b, which say that even in a case of deemed suspension, it shall not be over unless and until there is a order passed to the defendant. Which is, however, not is absent in 6. And thereby you can take the benefit under the proviso. Otherwise, no. You see the judgment, Rajiv.
Six accessory. 516.
516.
Mr. Datta nowadays is dealing with many suspension matters.
516. My lord, if your lordship, my lord, subsequent thereto, my lord, an order has been passed. At page, my lord, 35, my lord, your lordship will see order, this order. My lord, the aggrieved person has not been marked a copy. My lord, my lord, obtained this copy from the office, my lord, by filing a representation. Now, what it says that the show cause was issued on 30/11. My lord, I never received the show cause. This order is passed on, my lord, 1st of February. I have made a categorical statement, my lord, at page 8, 9, and 13. My lord, show cause is never served to me.
And not only a so-called, you see what these the revenue authorities are doing, you see, they have not taken Rule 9 too seriously. What they do is they appoint the inquiry officer, the presenting officer, and ask the authority, the person concerned, to submit whatever you want to submit. But how can you submit without a definitive charges being framed on the basis of the allegation?
Correct.
Mr. Who is appearing for this?
For Deputy Commissioner Lordship, I am appearing.
Who has done all this problem? You.
Lordship.
But Mr. S.K. Talukar, the learned counsel, appearing on behalf of the petitioner. Mr. H. Sharma appears, and Mr. S. Dr. appears for the respondent number 1 and 2. 1, 2, and
1 and 2.
1 and 2. Mr. H. Sharma appears for the respondent number 3 and 4.
Lordship.
You should notice making it returnable. When can you get the instruction as regards the memorandum of charge and all? And have you intimated about that you have been, they know that you have been released, no?
My lord, yes.
When?
I'm working, my lord, your lordship will see. My lord, that page 30, my lord, it is
What
page,
is this matter about this
20.
matter? The WPC, there is an order of 2/1/2023.
yes, my
Yes,
lord.
Lordship.
By this order, the honorable court directed, my lord, relegated me.
Challenging their suspension, Lordship, they have earlier approached this honorable court, and pursuant to the direction of this honorable court,
On the
that
motion
order
stage, my
is
lord,
passed.
the honorable court relegated me to the
Case
deputy
35.
commissioner for considering afresh. Subsequent thereto, this, my lord,
For considering?
considering the matter afresh, my
No, Lord.
under Rule 6.
Yes, Lordship. Pass a reasoned order by following the Rule 6.
Rule 6. Now,
And this is the
neither-
order passed.
No, that Rule 6.2, which has been mentioned out there, that is in terms with the proviso to Rule 6.
Lordship. That is,
But there are only 3 circumstances on which the proviso
Yes.
applies. But the fact, the proviso does not deal with the case of arbitration,
Lordship.
which have been held in Rekibuddin to the effect that the same principle also applies to deemed suspension.
But from this order, Lordship, it reflects that so-called notice has been issued to him, Lord.
Anyway,
that is
But
under
even then,
challenge.
Lordship, I will
I
obtain
have
the
stated, my lord, categorically.
okay, not necessary.
Lordship.
We will look into it. Heard Mr. Spencer today. You should notice, when can you get the instruction?
2 weeks, Lordship.
We'll have it on 10th.
Lordship.
10th of April.
Lordship. I will try my level best.
No, the level.
Lordship.
This is where?
Karimganj.
Karimganj. Nearby. You notice making it returnable on 10th of April 2023. as the respondents are duly represented by their respective counsel, the extra copies of the petition be served upon them during the course of the day.
Today, my lord.
The case of the petitioner herein is that he was arrested on
26/8, my lord.
26/8/2022
22.
in connection with ACBPS case number 34/2022. Thereupon, on 28/9/2022, the petitioner was enlarged on bail by the court of
My lord, the court of special judge, my lord, Assam.
Special Judge Assam. Full stop. Pursuant thereto, the petitioner joined the service
On 39, my lord.
on 30/9/2022. Subsequent thereto, the disciplinary authority, you are the disciplinary authority?
Deputy Commissioner, yes.
Lordship.
The disciplinary authority, on coming to learn, the appointing authority, on coming to learn that the petitioner was arrested on 26/8/2022, and he had remained in custody for a period of more than 48 hours, had put the petitioner in suspension with effect from 26/8/2022 by the order dated 29/10/2022, impugned in the instant proceedings. There was a challenge to the say suspension order on 2/1 in WPC number 8389/2022. And this court, by an order dated 2/1/2023, disposed of the same, directing the respondent number 3 to pass a reason order upon examination of the claim of the petitioner for vacating the suspension order as indicated. Suspension order. It was further mentioned that the said order should be passed by the respondent number 3 to be a reasoned order within a period of 15 days from the receipt of a certified copy of the said order. Thereupon, on 1st of February 2023, the order was passed in pursuance to an order dated 1/2/2023 was passed by the respondent number 3 in pursuance to the order dated 2/1/2023.
My lord, there is no reference to that effect in the order. Absolutely no reference.
Thereafter, it appears that an order dated 1/2/2023 was passed by the respondent number 3, wherein it has been mentioned that considering the seriousness of the charges against the petitioner, it has been decided by the disciplinary authority to continue the suspension period till the conclusion of the inquiry. It, however, appears from Annexion 9 to the writ petition that the said order dated 1st of February 2023, along with various other documents, were furnished to the petitioner on 6th of March 2023. The subject matter, as mentioned in the communication dated 6/3/2023, also gives an impression that the said order dated 1/2/2023 is in connection with the prayer petition of the petition. The learned counsel for the petitioner submits that the present writ petition has been filed challenging the suspension order on 2 counts. First, the suspension order was passed on 29/10/2022, giving it retrospective operation from 26/8/2022, and without taking into consideration that the petitioner, upon being enlarged on bail, was allowed to join his service on 39/2022. The learned counsel further submits that the suspension order, that the respondents are well aware that he had been enlarged on bail. Under such circumstances, the question of the suspension order continuing beyond 3 months from 29/10/2022 would be in violation to the law laid down by the Supreme Court in the case of Ajay Kumar Chaudhary versus so-and-so, reported in so-and-so, as well as the judgment of the division bench in the case of Rakibuddin Ahmed versus so-and-so, reported in so-and-so. The learned counsel appearing on behalf of the respondent number 3 and 4 shall apprise this court on the next returnable date as to whether the memorandum of charge, the charge sheet, have been submitted to the petition, have been served upon the petition. The respondent shall also produce, the learned counsel for the respondent number 3 and 4 shall also produce such memorandum of charge, charge sheet, which have, if any, further to that, the learned counsel for the said respondent shall also obtain instructions as regards as to whether there has been compliance to the judgment of the Supreme Court in the case of Ajay Kumar Chaudhary Supra, as well as the office memorandum dated. Yes, that day you gave it or Mr. Bora gave it. Where is it? 6/4/2010 or 6/4/2017, something, na? I forgot. Let the ulai dikla.
Fourth of February 2020.
4th of
February 2020.
2020.
Yes.
4th of February 2020. Issued by
Additional Secretary. Personal Department. Personal department.
Personnel department of the government of Assam. List according.
Obliged.
And number 6,
You bring on record that office memorandum, it will help you.
I'll bring on record.
But see, Rajiv,
Definitely.
your answer is, because I also thought, can it be possible? Because that is the answer.
Obliged.
Yes, Mr. Talukdar.
My lord, I paid for some time to implement the secretary, tribal affairs, director, but I may be taken up on next week. my lord.
Why?
Well, I will implement the director, tribal affairs.
Director Tribal Affairs.
My lord.
What is this Tribal Affairs? Tribal Affairs, you are to get the money from whom?
From
He has to get this money from this corporation, my lord. He was the employee of the corporation, my lord.
Corporation is here.
Corporation is there.
Is it required for
But,
Director of Tribal Affairs?
Yes, then my lord, he will have to serve this copy to Miss A. Sharma, my lord. My name reflects.
Oh. In fact, one should be the state of Assam represented by
managing director.
Represented by Commissioner Secretary, WPTBC, now it is tribal affairs.
but this one needs to be changed.
This
How
one will
can the
become two.
managing director of Assam Plains Development Corporation represents the state of Assam.
So I will implement my lord secretary.
You withdraw, Mr. Talukdar, and file a fresh one.
My lord.
Because here I think you have to make the
My lord,
state
my
of
lord, I
Assam
withdraw.
represented by the
Commissioner and secretary.
Commissioner and Secretary Tribal Affairs.
Right.
Because
And my lord, finance also usually finance is made a party. in
okay,
this case.
you also make finance. And in these tribal affairs, the corporation, Mr. Ansuman Sharma is there here. So
Right.
I think you have to give a copy.
Right.
But Mr. P. Talukdar, the learned counsel appearing on behalf of the people, and Mr. Hardhor, the learned counsel appearing on behalf of the tribal affairs department.
Now it is tribal.
The learned counsel for the petitioner has submitted that while arraying the parties, there has been certain mistakes committed. In as much as the Commissioner and Secretary to the Government of Assam Tribal Affairs Department needs to be made a party.
Director.
Further to that, he also submitted that the Commissioner and Secretary to the Government of Assam Finance Department also needs to be made a party. Taking into account the same, the learned counsel submits that he may be allowed to withdraw the instant petition with the liberty to file afresh. Taking into account this his submission, the instant petition stands dismissed on withdrawal. However, liberty is given to file afresh by removing those formal defects.
7,
May I take it, Lordship?
Yes,
Lordship, the petitioner was initially appointed as tribal officer.
you were. What do you want? What is your prayer? Pension order shall not particularly respond for to determine the rate of monthly. Yes, what is your case? Ask corrigendum against the pension payment order.
Already we have issued, but his grievance is that he ought to have been given 3,000 per month, but we are sanctioning 2,070 per month. That is his grievance. Perhaps
Just find it out.
because he's qualified, he has not completed 10 years of service. That's why it has come down.
If you don't give 10 years of service, does he entitled to at all?
No, with the approval of the government.
Oh, so that has been given, the 67.
No, one, yes. Interrupt.
If it is less than 12 months,
yes,
that is corrected under 67.
66, not
Huh?
67. Perhaps they have rightly calculated.
Okay, that I also have the satisfaction. But Miss
You have it.
you Hazarika, the learned counsel appearing on behalf of the petitioner. Mr. S.R. Bolu, who appears for whom?
I am for 1 and 3.
Mr. Ian Sharma appears for respondent number 1 and 3. Mr. S.R. Borua appears for respondent number 2 and 4. You appear for 1, 3, and 5.
I am also for 5, Lord.
1, 3, and 5.
1, 3, and 5, Lord.
He appears for 2 and 4. And Mr. R. Baputari appears for respondent number 6. Issue notice making it returnable. How much time do you want to get it?
4 weeks. Okay.
Have it on 28th of April.
Okay.
Issue notice making it returnable on 28th of April. As the respondents are duly represented, extra copies of the writ petition be served upon them by 27th of March 2023. The case of the petitioner is that the petitioner, that while granting the pension to the family pension or pension, the superannuation pension to the petitioner, the amount which have been given to him is rupees 2070, which ought to have been rupees 3000, 3000, for which the petitioner had represented before the authorities. As the authorities have not done anything on that, on the grievances of the petitioner is compelled to approach this court by way of the present petition. The respondents on the next date, on the returnable date, shall obtain instruction as to whether the petitioner is entitled to the claim as made in the writ petition.
Number 8.
Yes.
My lord, this case relates to the pension, my lord, the compassionate pension, my lord, and the husband of the petitioner died on 21/11/2000.
For that matter.
Yes, my lord.
I remember.
Yes, my lord. I have annexed also, my lord.
You have got that
Compassionate family pension.
compassionate.
Now, my lord, I have corrected.
Now it is better, more. Heard Mr. T.L. Polpuya, the learned counsel, appearing on behalf of the petitioner. Mr.
Lordship, I am for 1, 4, 7, and 9.
1, 4, 7,
9.
7, and 9. Mr.
I appear for respondent number 6, provident content.
Vanto appears on behalf of the
SK Chakravarti.
respondent number 6. Mr. J. Deka? J. Das. J. Das appears for the, find out, where is the accountant general? Number 5. Number 5. And then who appears for whom? Circle officer? Circle officer, government appears.
Lordship.
Mr. S.R. Borua appears.
And I'm for 3 also, Lordship.
And Mr. R. Baputari appears for respondent number 2, and treasury officer is there 10. Gita Malo, we have to issue notice. You just check it out, huh? Well, I've given you the name, but just find it out. Issue notice making it returnable on 3rd of May 2023. As the respondents number 1 to 10 are duly represented by their respective counsels, extra copies of the writ petition being served upon them by 29th of March 2023. As regards the respondent number 11, the petitioner is directed to take steps by way of registered as well as usual. On the returnable date, the learned counsel appearing on behalf of the respondent shall apprise this court as regards the entitlement of the petitioner as claim made in the writ petition.
Lordship, GA Assam name may be shown in the cause list.
Interim prayer, my lord.
Huh?
Some amount to be given to me.
Interim something. Let them find out, we'll give you. Liberty is given to the petitioner to mention the matter for upgrading.
Lordship, GA Assam name may be shown in the cause list.
The registry shall also show the names of the councils representing the respondents in the cause.
Lordship.
Item number 9.
May I take, my lord?
Yes.
So were appointed, my lord, as TSAR, my lord, prior to 2012, my lord. Thereafter, they acquiring DA degree.
Pursuant to?
Yes, my lord. As TSAR, my lord.
Ah.
Prior to 2012, my lord. After that, they acquired DA degree. Sir. As per their,
Oh, that one.
yes, my lord. Higher education, my lord.
Where is my order?
Yes, but page 86 here. My lord. The author of this honorable court.
Oh, my order. That is the B.Ed degree, 21/6.
Yes.
2007.
Yes.
Where is that order? My order?
Yes, my
The
lord.
moon order to 7/2/1203 of 2023. If I remember correct. 1203 by 1203 Universe of 2020. WBC. You got there's a requirement out there. You have to be in service somewhere. Now,
Yes,
where's
My lord,
the secondary education, the communication of 2016?
yes, my lord. Page 73, my lord.
Page
73, my lord.
73.
Regarding
Okay.
advance increment for acquiring DA degree.
Now, do you complete out here? You have
Yes.
joined before 3/7/2012?
Yes.
And have also obtained a B.Ed degree
Yes.
from UGC. Very well. And then how many respondents are there?
14, my lord.
Huh?
14. Oh, no, not my lord. Petitioner 14, my lord. Yes, and then,
1, 2, 3. Okay.
7 respondents.
203 देखिए 1, 2, 0, 3. You have taken orders in this regard, this type of matters. They have directed to do it within 3 minutes. They'll submit. They'll find it out. They'll pass the order. Your name?
M. Kolita.
M. Kolita and Mr. N.J. Kapani. I think Vijay has taken.
Item number 10. Day beginning.
Yes, what is this stay getting business?
My lord, I'm the applicant and the respondent of the petition. And this application is filed for a vacation and modification of interim order. My lord.
Yes.
Interim order at page 18, my.
Page 18 of your application.
Yes, sir.
ma'am. The relevant person is.
What is the order? Order of suspension?
Yes,
Was staged. Order of suspension was staged.
state, my lord. And
After
on the
hearing the parties and perusal of records.
Yes, Mr. Nayak.
Lordship. My lord, in the original, in the writ petition, my lord, when we filed it,
Yeah.
well, there was a order, there was a communication made to me on 23/9/22 saying that when I was the library in charge, there was some delay on my part, my lord, because of which the books could not be procured. That I had already, my lord, replied to, my lord, before the authorities by way of a representation. Then all of a sudden, my lord, they come up to me and ask me whether I know Bhagatlal Dotto and Amandip Ahmed. A letter was given. Then, my lord, I say I don't know both of them. Thereafter, my lord, all of a sudden, this order of suspension comes. I come up before your lord. On the first day, when the matter was moved, my lord, the Honorable Court directed them to produce materials before your lordship. Some documents here and there came and produced before your lordship, from where, my lord, that leaking of information was not coming out. The only thing that was coming out was, my lord, that I had some my lord, delay in, my lord, making those recommendations for the books. This Honorable Court said, for that, you can go and have a departmental proceeding. Suspension, my lord, is not called for. Thereafter, my lord, they now have filed this under 2263, although they were heard, be that as it may, on this and say that I have leaked information of the department, which led to making of complaints. The Amandip's application is not before your lordship by one Bhagatlal Dutta before the governor and the ministry, Health and Family Welfare Department, to which it was forwarded, has required the department to give a para-wise comment. My lord, if there is something which has been brought the functioning of the institution, that, my lord, they can always clarify. Why go for this which one to find if they are not guilty?
What is the scope of entertaining a repetition in this type of matters?
My lord, it basically was a suspension matter, my lord. I had
Understood. Suspension is okay, but
that much only. I'm not beyond that. These issues have been raised by them.
Don't you think that with due respect to the coordinate bench, they have decided the entire matter?
No, but cited the entire matter in the order because that matters were placed before the court.
Or didn't its court assume the role of a departmental authority?
No, my lord, it never said. The court said that you can always proceed in with it with regard to a departmental proceeding.
What remains after these findings?
No, with regard to if they have materials with regard to, my lord, Official Secrets Act, as they are trying to, my lord, project in the repetition, they can always proceed against me. I'm not on that, my lord. But the only material that was there before the Honorable Single Judge was that of, my lord, delay in, and my lord would come to page 23, my lord. Oh, sorry, my lord. Page 22, para 9. In the circumstances by earlier order dated so and so be required.
Can we look into all these things?
My lord, it was only for a prima facie satisfaction.
No, but then Mr. Nair, one has to be that one cannot transform this court into a court of
I got what, my lord. There are 12, my lord. The Honorable Court has said.
Unable to accept any serious allegation of misconduct. How can a finding be
Because,
given?
my lord, it was only on the basis of the documents that were produced before your lordship.
Whatever, maybe can we see it?
My lord, the Honorable Court had brought it. I was a spectator. My lord, there are 12, my lord. And understand where, my lord, that we are unable to access so and so, and if we had not submitted the list of recommended books made by the faculty member within the time expected by the authorities, prima facie, it appears the same cannot be.
I understand, Mr. Nair, the suspension, yes, if it is a case of malafide out there,
lordship,
you can. Or it's a cross abuse of the power, you can.
That's what I was arguing.
We are not on the other.
My lord, that other things, my lord, it's tentative.
What is the evidence? How much evidence? Yes, what is the stage of department?
I have stated that 8 files were chaired by the petitioner.
Understood. What is the stage of departmental proceedings?
Proceeding is going on, but on the basis of the interim order, he resumed his duty and resume his duty, on the basis of the.
Understood. Okay, but you can always have you placed him in some other place?
No, my lord.
You placed him in some other
I'm not
place.
in my department.
My lord, it is a violation of the CCS rules, my lord. That's the point that I
No, what is the present state of the
This is my
department? No, Mr. Datta, you should have challenged this. You have put this court in a very embarrassing position. It would be something when these findings are being given by a coordinate bench, it becomes very difficult. These are almost final observations which are, right? I can only say, only one thing I can say, while disposing of your stay application, that observations made hearing in this order shall not affect your departmental proceedings. That is only I think I can give it. And if you if you want that liberty, you can very well file it. Because the problem out here, you see the embarrassment of this court. If this court have to, because these are categorical findings given by a coordinate bench, how can it touch it? I can't say that the coordinate bench is wrong.
My lord, we have a problem, my lord.
I understand, but why haven't you filed an appeal?
My lord, I am another payer also.
Yeah.
For a direction to the, I have already filed laws and FIR against them. They can detect, unveil whether they have shared official documents to other person. It is the domino under the executive agencies, my lord. This may be directed, my lord. I have prayed through this.
What have you paid?
I have already. My lord, please to modify and or to amend or recall or vacate the interim order related substances, and we further please to direct any investigation to investigate the matter, allow the institute to complete the disciplinary.
No. Is there a stay to the departmental proceeding? No.
No,
can-
already we have
That is already there. So you can. As regards the investigation, you want to do it through an investigation, you carry out, want to do it, do it.
we have already
Permissible under law.
already filed. I have an FIR at page, my lord.
No, Mr. Doctor, if you want to, for an investigation, you want to do it, that is, you do it as per permissible under law. This court, the order passed by this court staying the suspension shall not affect your right to that effect. I am not going to direct for investigation. Mr. Doctor, kindly don't make it, don't think it or have an illusion to that effect. No, this court is not going. You can very well go ahead with an investigation if it is permissible, but the order passed by this court shall not come in the way. And the observations made in the order shall not affect your disciplinary proceedings. That is the only thing I can do.
But we have no authority to see the email until unless the petitioner cooperate. There's others email.
So you want to open his email?
Yes.
That email can be nowadays opened by under the provisions of the information technology, how it is to be done. The law, these people know it. And you are for the Union of India. You know it better.
We have already laws.
Mr. Nair, keeping this matter, the
No
order
problem.
intact.
I wanted it closed on that day only, but my lord, what the court wanted to see with regard to that, we wanted to go into the allegation that was there. That's why it's there. Otherwise, my purpose, my lord, with that order, it's served. And my lord, with regard to department proceeding, if they initiate a department proceeding, these orders, my lord is correct in saying that this will not be. This is tentative use. There is no show cause till now. No memorandum till.
You want to do it? Go ahead.
It's up to them, my lord.
You can go ahead.
My lord, beyond this,
I'll dispose it of. I'll dispose it of the instant petition, taking into account what has been held by the state, because this seems to be a detailed analysis.
Logic.
And I'll only clarify to the effect. And as you have not filed an appeal against that, I will only file an because Mr. Dutta, kindly understand, this court under no circumstances can touch these findings. It becomes very difficult. So this court will only clarify that you can very well go ahead with your proceedings, departmental proceedings. For that, if you need for carrying out such investigation by whatever agency, you are at liberty, you don't require liberty from this court. That is it. And the observations made herein in the order shall not affect you in the departmental proceedings. That's all. Only this will be taken, this order shall be taken as only to the purpose of stay of the the suspension order has been interfered. That's all. Without going into other aspects.
Lordship.
That is the only thing I can give you.
But on the
And you want to put him, what is this? He's working in which place?
There only, the institution only.
What is that place?
my lord,
Tezpur, mental hospital, Tezpur, my lord. Is a
Mental
doctor.
hospital, Tezpur. And it is under whom?
My lord, it's under the government of India, and the government of Assam also has a.
So this is under
Minister of
government of
Land.
India.
No, my lord, Northeastern Council. It's under the NEC.
You put him in some other place if you want. Any other place?
No, I have already
available.
been, I'm not in my department. I've already been divested of the charge of library. I was holding the post of deputy director, that also have been taken away. And now I'm in a my lord, consulting that, interacting with consultation with the, my lord, the, what do you call that, my lord? The persons who come there.
So that has been taken care of.
I was in the
So there's
Department
no
of
problem with
Psychiatry.
that. So suspension, if this court has already opined out there, this court can't touch it.
Patni or the my lord,
Huh?
as you lordship think.
No, because Mr. Doctor, you have seen the order.
My lord, on-
It's a detailed order dealing with all allegations. And being a coordinate bench, I can't touch it.
on this issue, my lord, one is out of service, one is resume his duties on the
You
petition.
know what is to be done. I don't I'll ask this court to step into your shoes. Okay. But Mr. UK Nair, the learned senior counsel, is assisted by
A Borman.
as well as Mr. AK Doctor, the learned counsel appearing on behalf of the respondent number 1 and 2.
No, my lord,
1 and 2.
yes.
1, 2. Yes, your lord.
One, two, my lord.
The respondent number 1 and 2 have sought for a modification, vacation, and the alteration of the order date 21/12/2022, passed in application number 8193, passed in the instant writ petition, for which an interlocutory application has been filed, which is ISC number 630/2023. It is also relevant to take note of that in the prayer made in the said interlocutory application, the respondent number 1 and 2 have not only sought for vacation, modification, or alteration to the order dated 21/12/2022, but have also sought for a direction to the investigating agency to investigate the matter, allow the institute to complete the disciplinary proceeding in an uninfluenced way. I've heard the learned counsel taking into account that any decision in the interlocutory application will have an effect on the merits of the writ petition. This court have taken up the matter for final disposal at this stage. I've heard the learned counsel for the parties. This court, upon perusal of the order dated 21/2/2022 passed in the instant repetition. I've heard the learned this court have also perused the order dated 21/12/2022 passed in the instant repetition. The said order is a detailed order taking into account the detailed order after hearing the respondent in the respondent number 1 and 2 in the petition. And after taking into account various aspects of the matter which was duly placed. Being a coordinate bench, it would not be proper for this court to sit over the observations and the findings arrived at in the order dated 21/12/2022. Under such circumstances, taking into account the observations so made by the coordinate bench in the order dated 21/12/2022, this court sets aside this court while conferring upon the said conferring to the reason assigned in the said order. Sets aside the suspension order dated
12/10/2022.
12/10/2022 impugned in the instant proceeding. Taking into account that the suspension order have been interfered with by this court, for the reasons stated herein above, this court, however, would make it clear that the observations in the order dated 21/12/2022 has to be taken only as observation in pursuance to the order, as an observation to the challenge to the suspension order dated 12/10/2022. Therefore, the said observations made in the order dated 21/12/2022 under no circumstances shall affect the rights of the respondent number 1 and 2, or shall have a bearing in respect to the departmental proceedings which the respondent number 1 and 2 in respect to the departmental proceeding against the petition. The inquiry officer shall be in the cases such departmental proceedings are initiated against the petitioner, it is made clear that the inquiry officer shall proceed with the inquiry without being influenced by the order dated 21/12/2022. There's a prayer also in the interlocutory application that seeking a direction. Upon to an investigating agency to investigate the matter. Taking into account there are proper provisions, taking into account that the provisions of the Code of Criminal Procedure 1973 duly provides adequate remedies for that. This court is not inclined to pass any direction for making an investigation. However, giving liberty to the respondent number 1 and 2 to take appropriate action as deemed fit in terms with the provisions of the Code of Criminal Procedure 1973 or such other applicable provision under law. Anything else? With the above, the instant writ petition stands disposed. Taking into account I heard so and so, taking into account that the writ petition has been disposed of, the connected writ petition has been disposed of by an order. Taking into account that the connected writ petition has been disposed of, the instant interlocutory application also stands disposed of in terms with the said order.
One of the suspension order has been interpreted.
Oh, I've said that.
Much of that. He's working as an associate professor. Nothing else. Even that OPD thing is not with him.
You have removed him from that place.
No, only I'm in the teaching manner. I'm not in any other job. Only teaching. And this is a one institution. There is no other branch.
We'll make that statement out there. That you are presently working
only as an associate professor.
It's just one line, huh?
No administrative.
It has been also submitted. I'll put it on top. It has also been submitted by Mr. Yukenai, the Learned Senior Counsel, that at present, pursuant to the reinstatement by virtue of the order dated 21/12/2022, the petitioner is no longer serving. The petitioner is no longer serving in the library.
Library or in any administrative work.
Or any administrative work.
He is in the academy.
He is only and therefore he submits that the question of suspension of the petitioner interfering with the order dated 21/12/2022 does not apply. That I'll put it.
And even Malad, they are not giving me OPD works. That's the tragedy. That they can, there is nothing there, Malad. They can give me.
7. Order implement the party.
He is seeking treatment of the opposite party number 2 matter, the headmaster of Factory High School, Nogam, in place of the respondent number 3, the opposite party number 1, headmaster of Katopati Town. This was an error on my part.
Whom do you want to bring?
My lord, Headmaster Kachori High School, Nogam.
By removing
Katomoni Town High School headmaster.
You want to remove that. And why?
It was a typing error on my part, my lord. The Katomoni Town High School headmaster is over connected to the
Mr. Bhartwaj, the Learned Counsel. B or P?
P, my lord, Laban.
The learned counsel for the applicant. P. Mukhari appears on behalf of the secretary. The instant application has been filed for insertion of a party, that is Headmaster Kasori High School at Nagaon, PIN 782124, as well as for deletion of the name of the respondent number 3 in the writ petition. The learned counsel for the petitioner has submitted that on account of typographical error, it had resulted in wrongly impleading the respondent number 3 in the accompanying writ petition, which ought to have been the Headmaster Kasori High School, Nagaon. Taking into account the same, this court have been taking into account the same, this court deletes the name of the respondent number 3 as appearing in the accompanying writ petition, and instead impledes the Headmaster Kasori High School, Nagaon, PIN 782124, Assam, as the respondent number 3 to the instant writ proceedings. The registry is therefore directed to make correction of the records in the accompanying writ petition on the basis of the instant order. I stands disposed. Main petition of the letter. Heard Mr. P. Bhartwaj, the learned counsel for the petitioner, taking into account the order passed in the accompanying interlocutory application being IA bracket civil 328/2023. Issue notice to the newly impleaded respondent number 3. Steps be taken by the respondent petitioner by way of registered as well as usual within 1 week from today. Please stop there. What is the matter about?
This is regarding non-payment of ATR incremental benefit.
This is the matter on 12th of May 2020.
Production list item number 2, stay matter.
If I may, my lord, refer to order dated 24th of February 23 passed by your lordship. This was the matter wherein allegation of sexual harassment was made. Ultimately, a compromise was reached. Thereafter, a complaint defense was raised that there was some evidence that part of the order should be rectified or modified. We took a chance. The proceeding was going on against us again. So we approached this honorable court, and lordship was dealt with the matter at length, and eventually was pleased to grant a stay. That stay order is operating till today. Justice service completed. Respondent number 7 has entered appearance below.
Who is appearing for respondent number 7?
I am on behalf of R. Goswami, Atul Goswami. R. Goswami, I am on behalf of my lord. He has instructed me to take some time for filing affidavit.
Yes, my lord has heard the matter.
File my affidavit.
Your file.
No, but I have instructed to take some time for file.
This matter, lordship is on the facts and law, lordship is then exhaustively minute, and Mr. Dubey was also submitting the other day. May I pay this matter to think as part of matter?
Why?
I need your lordship.
Sometimes, my lord,
I may have a good case on law, fact may be bad. Perhaps my friend is on that.
This is interim protection. What you wish, please, that may be until further orders.
Mr. Mr. R. Dubey, the learned counsel heard Mr. S. Bonik, the learned counsel for the petitioner. Mr. R. Dubey appears on behalf of the respondent number 126 and Mr.
Yes, Bhattacharya, my lord.
P.S. Bhattacharya appears on behalf of the respondent number 7.
Yes.
The learned counsel appearing on behalf of the respondent submit that they would require some accommodation for the purpose of filing their affidavits. Taking into account, let the matter be listed again on 15th of May 2023. The interim order passed earlier shall continue till then.
Till then, until further orders, because otherwise it stays. Till.
I number 12 to 18 for admission.
May it please your lordship.
Hmm.
Lordship, we kindly adjourn the matter for the day as my senior is on leave and I had given an adjournment slip also yesterday, lordship.
Matter pertains to
My lord, the regularization that the illegal irregular teacher regularization and payment of salaries for the period where we claim they were working against non-sanctioned posts.
excess.
My lord, they were illegally or
They were brought within this 2020.
yes, my lord, they are there within that scheme. They were given, some of them have been given appointments. And my lord, if they have accepted those appointments, perhaps the earlier claims, my lord, in the appointment letters, they have given that undertaking. That would require reconsideration. I am also looking, my lord, into the claims of all the connected writ petitioners. This is a repetition by the state. The first item is a repetition by the state against an order passed by the Assam Administrative Tribunal, my lord, where we were directed to pay the salaries despite the fact that they were found to be appointed against non-sanctioned posts. So we have filed a repetition against the order of the Administrative Tribunal. And these persons have participated in the screening and scrutiny committee, my lord, and they have, many of them have been given.
Which committee?
My lord, after the Manohan committee, there was a subdivision level committee which went up to the district level and then went up to the state level committee. And we had classified teachers as illegal and irregular. And thereafter we had offered fresh appointments to many of those who had actually, who did have the qualifications to be appointed as teachers or tutors from 2021 onwards, madam.
2021.
My lord, yes. And the appointment
Those
letters.
who had qualification, less no qualification tutor,
Yes.
qualification teacher.
Yes, madam. And in that appointment, in that offer of appointment, we had given a condition that they would have to keep up the past claims in case they want to be now appointed. Those who have accepted those appointments, my lord, their repetitions or the orders by the ATA would now not be functional against them. Is our submission. And those who have not accepted those appointments, perhaps they can continue with the litigation.
These petitioners have accepted.
My lord, those are my verbal instructions. My lord, I have asked them to put down everything. But all the petitioners, all the series matters, my lord, all these series, I want the.
They just stay.
Yes.
And the
Because
matter has
orders
been
were to
going from
pay the salary.
2015. And these people are working. Mr. Mazumdar, one thing is it becomes very difficult for this court to understand. These people are working where? They're not working in venture schools. They're working in provincialized schools. How are they working?
They claim to be working. They claim to attend classes. There are no attendance
I
sheets.
hope you have control over those provincialized schools. Do you have or not? If you don't have, if you have the control, then how are they working? Are you given, is the headmaster out there?
Yes.
Assigning them work?
We do not recommend. The headmaster says that he issues a working certificate. She has been attending school or he has been attending school.
How is it possible?
It is on basis of those documents that we could not deny them everything, and now the decision from the cabinet has come to give them fresh appointments and allow them to.
Understood. Those who have done it, but those who are not, how are they
But
working?
for those who are not, we had concrete evidence to show that their claims that they were working or they were appointed at any point of time, my lord, they could not substantiate it by any means. For
Because
those,
as if I remember, the figure is around 841 people
yes,
who have been given this appointment.
more than that. This teacher tutor appointments in 2021 was more than that. Initially, it was 841. We had classified some 138 at first in 138 or 137 were first given the appointments. Then when we found initially, some 137 persons were given the appointment, that the rest were all found to be illegally or irregularly appointed.
One thing this court is baffled. How, if the government has now the control over the school, how are people still working? And how, why the headmaster are still allowing or assigning them work? Why this government is not taking, isn't it a tacit approval by the government?
Keeping all this in view, this thing, at the very local level, at the town level,
You have no control.
There was a point of time, where we could not, we were very
We are concerned now. As of
now, as of today, because she could not find persons, such persons making any sense. These claims would be to a point prior when we had taken up that exercise to identify the
prior
illegally.
to 2020 or earlier?
It is from 1991 to around 2001. It was a very difficult case for us, and therefore, with all the court, with all
So
the
after
litigation,
2001, there is no person working.
they are working, madam.
How
They
is it-
claim
how
to be
are they
working. Even
working?
in 2014, madam, they claim to be working.
How? And you have also accepted some people who have worked till 2016-17, because that day I was dismissing some matters on the basis of that particular clause 2 of the appointment letters, whereby they have given the joining reports to the effect. How are they still working? Because wouldn't that come later on that you have taken the work?
Yeah.
If you don't issue strict instructions to the headmaster, how are they being assigned the work?
That has been done. That has been done now.
Then if they are not doing it, if you have done it, then why is the headmaster thereafter issuing that they have not received salary for this period? And what actions have you been taking against such headmasters? Nothing.
I'll have to ask the department as to what action against each of the headmaster is coming up.
Understood, but you will ask the
But
department, but does it look nice that these people are still working? And the problem is not there with the education department. The problem is with these teachers, they render service. The education department gives a tacit approval, and the problem is caused by the finance. Isn't it, Mr. Borbuzari? These are teachers who are working. The education department, I don't know how, are still allowing these people to work. And the headmasters of the school, I have come across, they keep on giving non-royal certificates. And on the basis of this, the persons come up and look at, I have been working. How are they working when the government out there categorically does not allow? Because if you see all these acts from 1977 onwards, all these acts, there has to be something to put an end to this. This provincialization method, you were provincializing the services out. Why? That who were left out, you have provincial. The drop teachers case. These are people who have been provincialized. In fact, it is something like a provincialization only on the basis of a resolution being taken. We have brought them up. But how still people are there? If their rights have already ended at the stage of drop teachers in 2003 or whatever happened in 2007 or 8, 9, how are still these people, all these requisitions, most of the requisitions are from 2015 saying that I've been working till 2015 and I have not got the salary from 2000 so and so to so and so. How are they rendering still service?
Because
you take their service, the education department takes their service, and thereafter you put the objection that who are they?
because my lord, recruitment has to be made in accordance with the rule. If the recruitment is not in accordance with law,
that is why you are not paying. But why is the education and the department allowing it? In spite of you having a particular office memorandum on 14/7/2005 stating clearly that without SIU approval there cannot be any appointment. If that be so, how is it these things are still happening?
Not to speak of that office memorandum, there is a statute, direct statute, that is, my lord, the AFRBM, which clearly
It is on the same date, both have come. That office memorandum has come, AFRBM has come. Both of them have come on the same date, 4/7, if I am not wrong. 4/7 is the date. So if that is so, how this is happening, or is the education department kept outside the purview of this AR, this particular act?
I cannot comment because that is not within my domain.
Which is?
Education department.
No, education department is not in your domain. But why the petitioner is not getting it is absolutely exclusively within your domain. The education department forwards all proposals to you, and you say, no SIU approval, nothing done. And thereby the domain, and these are all matters for area salary, if I'm not wrong. Well, how is it possible? How are these people working till 2015 and not getting their salary? You see this matter? This I don't know about the state. This is the state filing it. But other matters are where they have been working till 2015. How is it possible? Why you are not taking action against those headmasters? They're taking their services out there. The headmaster can very well say that, no, we are not assigning you this particular job or not giving you unless you get some orders from there. And this thing will keep on continuing. It's not no end. You are trying to, what you call, freeze out the things out to that effect, but it is not happening. Nothing is happening. That act of 2005, which you have brought it, is basically for that purpose, to freeze out that no further appointment shall be made without the SIU approval.
Because we have to consider the larger financial discipline of the state, financial health. If we go on, my lord.
No, but at the end of the day, this court also has to have a humanitarian approach. You have been taking their services, doing everything, something has to be given to them.
Yes, to be a parent.
We always can't apply that law as laid down in the case of Maruti Udyog. That sympathy doesn't hold water. Okay, at the request of the learned counsel for the party and for the petitioner in appearing on behalf of the respondent, and no objections were given by Mr. R. Majumdar, matter stands adjourned for 4 weeks. But madam, next time don't make a ask for an adjournment on the senior counsel. Unless he wants to leave his senior counsel became at par with you, don't make that out. The senior counsel adjournment I don't Yes.
This petitioners, they are seeking for grant of the pensionary benefit under the scheme.
Which scheme?
This scheme, which was it initially was with the Burma Oil Company, with the acquisition of the shares of the Burma Oil Company and expect with the Oil India. The Oil India has inherited the fund, and it provides the eligibility for the beneficiary. Now, from the RTI information that was furnished by the authority, it appears the requirement is for the permanent employees.
Where is that impugn order in HIE?
Lodge.
Where is Oil India? Your Oil India?
Yes, sir. Page 59.
Order on Now, Mr. Sakya, can you come to page 31 and 32? These are the three pension schemes.
Three pensions.
Which one you are asking for?
Hello, I am asking for the Oil India pension fund, number one.
Number one requirement
At page
is
30.
you have to be. What is the requirement?
Employee under the Burma.
As to the extended benefit to the members of the existing accordingly to employees who were members of the Burma Oil Fund will be automatically admitted. Are you? Number one?
Number one, I was not the employee of the Burma Oil.
Okay.
I was the employee of the
An employee
Oil
of the company as on 14th of October 1981 who was not member of the existing fund but was otherwise eligible upon confirmation for membership under the rules of the existing fund.
Yeah.
May make an application to the trustees in such form as may from time to time be prescribed by the trustee, and such applications shall be submitted to the regional office who have been reappointed after retirement. Nothing contained shall be decided to the trustee or the deputy trustee. So you are making your case under B. That you were otherwise eligible upon confirmation for membership under the rules of the existing fund.
That's my category method. And this, your lordship may kindly the particular act is annexed similar affidavit in opposition. I will take your lordship to some of the basic ground in this order. Your lordship will find the rejection is that I am not a permanent employee. At page 33. Therefore, page 33. Therefore, an employee will become member of All India Pension Fund OIPF under two circumstances. Any permanent employee who is a member of the Burma Oil India Pension Fund as on 14 October 1981 will automatically be admitted to the membership of the fund. Any permanent employee of the company as on 14 October 1981 who was otherwise eligible for membership of the existing fund may make an application to the trustee to admission of the membership. But this permanent word, it is not find place in the act, which is annexed to the affidavit in opposition. You will find it's at page 55, running page 55.
You were appointed against permanent post only after appointed date 1 year on different date.
That has, earlier to that, I have been appointed on different dates which are given. This is prior to the appointed day. Now, what they try to say, these are the temporary appointment. There are break in services, and we have been recruited for certain leave vacancies, etc., which we deny. We said that continuously we have been working. These are artificial break in services, and the payments are made. Even we are registered with the this Provident Fund Act. And since the date of joining, the contribution are continuously given to the.
But were you otherwise eligible upon confirmation?
Upon confirmation, because an application has to be made, and the trust, it is controlled by a trust. All the decision with regard to the eligibility, etc.
So upon confirmation, would it mean after 81 also?
Yes. Yes. Because this has been inherited, they have made a trust deed subsequently. The similar provisions are incorporated there, and we have made the application, but no result was there, and we are under the expectation that as it is there, we have been covered.
Yes, Mr. Nair, what do you say?
My lord, there are two aspects here, my lord. If he was come from Burma Oil Company, he gets it, or he is a permanent employee on 14/10/81, madam.
Where do you get a permanent business?
My lord, because the otherwise, my lord, the employee, my lord, a temporary employee will not be covered under our standing orders.
Yeah.
There it's defined. What is a permanent employee? What is a permanent employee means, my lord, a person who is put on probation for 3 months or 6 months, and thereafter, my lord, regularized. These persons were appointed at that point of time initially. They are brought on record. They were against leave vacancies, or my lord, some temporary vacancies have occasioned deputation vacancies. They were put into service. Subsequently, my lord, they were offered appointments on permanent basis on probation. They completed their periods of probation and they were appointed. This issue of coming under OIPF, my lord, the All India Pension Fund, never arose. Subsequently, my lord, we came up with the third scheme. That is, my lord, the All India Superannuation Fund. Under that, if your lordship can come to page 70.
Page 32?
Page 32 is, my lord, the OIPF, earlier one. A new scheme.
31 is the early one, 32.
Oh, pension scheme. Yes. 32 of the petition. My lord would have the third one. Oil India Superannuation Fund, which can be availed by an employee who was on roll on 1/1/2007 and who was put in minimum 15 years of service in the company at the time of superannuation, who joined the company after 14/10/1981. So, my lord, they were enrolled in this scheme. And my lord, all of them have superannuated by now. And all of them, my lord, we had bought annuities in terms of that from LIC. And my lord, they are drawing pension accordingly. Excepting one, my lord, because his annuity he has not converted. We have deposited it, but he has not converted it into, my lord, pension. Be that as it may. He went on voluntary retirement. Now, in that OIP, in the scheme, the third scheme, my lord, there is a condition that if you have to be a member of that scheme, page 70 of my affidavit.
Yeah. Page 70 of the petition or your affidavit?
Affidavit, but it's Annex R7.
Yes.
My lord, one point, the scheme is, my lord, 1.1, 1.5, my lord. Oil India Superannuation Fund will be applicable to, my lord, I've read that. The scheme will also be extended to unionized employees of the company drawing pay in the regular scale of pay. However, the scheme is not applicable to the following: contract, temporary, executives on deputation, apprentice, employees covered under the Oil India Pension Fund. So anybody who is covered under the Oil India Pension Fund will not get this benefit. So they were brought in, they continued. Thereafter, my lord, nearing superannuation, they raised this demand that we'll have to put in OIPF. And OIPF, my lord, and my lord, here we have brought on record, if my lord is in holding that, page 108, my lord.
108
of the affidavit.
Yes.
My lord, this is the appointment on temporary basis. This affected on in case of, my lord, the petition number 1 on 33/2/2012, and my lord would see at 109.
2002.
2082, my lord, sorry, 82. My lord will have it at page 109. The review. 3, my lord, a period under review from 23/382 to 22/682. Good things, it was reported, and thereafter, my lord, at 110, he was confirmed. We are pleased to advise you that on completion of your probation temporary period, so you have been confirmed the job main program as sweeper at the rate of pay of ₹200 per month with effect from 28/6/82. So, my lord, the entry in permanent basis being after 14/10/81, my lord, he will not be covered by that scheme. If he was, my lord, under this appointment earlier, say before 14/10/81, and then he got confirmed.
What do you say about this thing? An employee B at page 31. 31 of the petition.
Lordship. An employee of the company, my lord, he was not an employee of the company. He was a temporary contingent worker or casual employee.
So as at the word is an employee of the company.
As at 14/10/81. It would be
was not a member of the
but was otherwise eligible. Upon confirmation for membership under this rules of existing fund, may make an application to the trustees in such form or as maybe as from time to time be prescribed by the trustee.
Although he was not member, but as on 14/10/1981, he was entitled to be confirmed.
If there is a confirmation pending against him.
He was not member, but he had the confirmation.
No, my lord, if I may, if I have understood it, my lord, he was appointed, say, my lord, in June 1981 on probation. So, my lord, he will not be an existing employee on that day. But, my lord, because he was a permanent employee under probation, then on completion of his confirmation, say after 3 months or 6 months, whenever he completes his confirmation, he can make an application to the trustee that, see, I was there before 14/10/81 as a regular employee. Now I have been confirmed. Consider my case for incorporation. 2 requirements: that he should be a permanent employee before 14/10/81, and then the confirm. Because, my lord, the word used is employee, but my lord would see it's followed by a word requiring confirmation.
Now, if you see the remaining portion
Lordship
of that particular B,
Lordship,
there's a requirement of filing an application.
Lordship.
Otherwise, the person normally comes without any problem. As per 1A, he automatic. As
1B,
regards an employee of the government company as on Swen,
Lordship,
who was not a member of the existing fund.
but was.
So, but was otherwise eligible upon confirmation.
Lordship. Under the rules of the existing fund. The rules of the existing fund, my lord.
No, then how do you In what time have you mentioned about filing an application?
My lord, it would be, if I've understood this correctly, my lord, it would be for all employees who were appointed on probation before 14/10/1981, because the probationary period is 3 months, my lord, 3 to 6 months. And all those employees, after on confirmation, they can make an application and then the trustees will consider. It's not automatic.
But what do you say? Upon such application being filed, the employee shall be admitted as a member?
Lordship. Because
wouldn't that be a mandatory compliance?
my lord, if he but there will be two requirements. One, he will have to show that he had a permanent employment on probation before 14/10/81. Then he will have to show that he had been confirmed after 14/10/81. Third, he will have to
Why
show
are you bringing the aspect of permanent employment?
because
it
my lord,
doesn't
it's
say-
confirmation, and that has to be read with the standing orders.
No, understood.
Lordship.
I accept your argument to the effect. These people, some of the people became confirmed in the year 82.
80, all of them. 82 and then.
Yeah. If we do, without reading the word employee meaning a permanent employee, why wouldn't the petitioner come in?
Because my lord, he did not have a confirmation on that day.
But
He
the
did not have an
confirmation can
employment.
be
No, my lord.
subsequent.
No, my lord. Because there is a reason for this. It says, the standing order says a permanent employee will be a person who is appointed on probation for 3 months and not exceeding 6 months, which will be followed by an order of confirmation. Then, my lord, he becomes a permanent employee of the rules. Temporary employee means who has been engaged for a nature of work which is not continuous. The wording is engaged for a limited period for work which is essentially of a temporary nature, including project work, or who has been employed for temporary increase in work of a permanent nature. So here, my lord, now reads this. B. An employee of the company as at 14/10/81 means an employee who was there with a regular or a probationary appointment, but got confirmed after 14/10/81, then, my lord, he can make an application and then come in. That is not automatic. If he does not make an application, he will not come in.
Why does this court have to hold that an employee means a permanent employee?
Because, my lord, the word used is employee with confirmation. He was, my lord,
They were confirmed in
no,
82.
no, 82, and they were appointed in before 3 months or 6 months before that, my lord. The confirmation is not without something in between. My lord, the temporary appointment and confirmation, my lord, I would have understood the arguments made, my lord. Here, the temporary appointment is there, followed by a regular appointment. And then the confirmation.
Where is the regular appointment?
Lordship. My lord would come to page
110?
108, my lord. We have given of all the engaged manner with so and so requisition dated with reference to your requisition dated so and so, we have directed so and so to report to you for duty on 23/3/82. The engagement is purely on temporary basis on probation for 3 months.
So it may be probation or
Probation. It's a probation. Then, my lord, page 109.
when does a person go into probation?
When, my lord, he is given a regular appointment. He's given a regular appointment.
So he may be in probation.
No, he is not. Because
there
this
is no
came in
striking
82
out.
only, my lord.
There's no striking out.
This is no, my lord. This is on probation. The appointment is purely on probation for 3 months. Earlier, he was, my lord, against leave vacancy and all those vacancies. Temporary, casual. This gives him, my lord, certain permanence. And then, my lord, would see period at page 109. 3 months. Period under review from 23/3/82 to 22/6/82. Good. Then, my lord, the confirmation of patients. Confirmation. We are pleased to advise you that on completion of your probationary temporary period from so and so, you have been confirmed in job grade 1, main program at the rate of pay of rupees 210 per month with effect from 23/6/1982. So he completed 3 months, he was given permanency.
Let us see his earlier appointment.
My lord, that is there, my lord. At my Kailash Balmiki, petition number 1 at page 81, my lord.
What about page
81 of the R8. My lord would see he was engaged on 21/9/81. Department is CMO, sweeper, 210, temporary leave substitute.
Annexure R8.
R8. Top, my lord, temporary leave substitute. And my lord would see there are different engagements, my lord.
If you see R8,
Lordship,
what are the dates given here?
my lord, it's not very clear.
From what I could see with my
My lord,
eye, it is
21/9/81.
1/4/1990.
No, my lord.
Yes.
21/9/81, the top portion, my lord. Left side, my top. That's the first appointment. 21/9/81.
But what are the then after repay
210.
remarks date?
Pay, department, occupation, date, department, occupation, pay.
Then
This is, my
remark.
lord, the format
Then
we
remark.
maintain. Lordship,
After pay,
Lordship.
remark.
Remarks, temporary leave substitute.
Understood. Then date.
Then, my lord, the next one, that is for the after 1493, 1490, it goes, my lord. Here. It should be a new one, my lord. Because the page.
How is it possible if you have been
I
confirming?
got a better one, my lord. My lord, 21/9/81, temporary leave. Then, my lord, it goes on. And then, my lord, in 90, they have been given a revision, my lord. My lord would see 1890 is there, 1490 is there on the left hand side also, 932. But there is a revision.
What about this 1991, 92, 2000? Till 2000, these are there.
My lord, this is his my lord, chart, the card we maintain, my lord. Service book, you can call it, my lord, if required.
Then why
Because, my lord, what happened here?
No, once he has been confirmed in 82,
Lordship.
why we are getting the dates of 1990?
No, because this is going on, my lord, thereafter.
How can it be? If
No, this is not only for, my lord, that temporary period. This will be for his life. Because why I'm pointing this out to, my lord.
So does it show from this document?
This is, my lord, we have annexed it as a service book, my lord.
Has been confirmed? Because if you see down below 83, there's some.
My lord will have page 8 of my, my lord, that affidavit, my lord.
8?
Page 8.
Yes.
My lord, name, registered number 9/6592. Date of joining 21/9/81. Then he was discharged on 19/10/81. Then, my lord, he was again re-engaged on 22/10/81 till 29/12/81. Like this, my lord, he went till 7/11/83. Thereafter, my lord, he was put on probation on 8/11/93.
What is his name?
My lord, his name is Kailash Balmiki.
And we are concerned with 113 with what? SP Valmiki.
Kailash, no, page 81 is Kailash Balmiki.
Where is the
page 81 of that affidavit?
No, page. Okay. Page, what about page 113?
113 is, my lord,
SP Valmiki.
SP Balmiki. Okay. SP Balmiki. SP Balmiki would be, my lord, Sukhpal Balmiki. No? Sukhpal Balmiki. Sukhpal Balmiki would be, my lord.
Page 8. We will get it in page 8.
Lord. Is there? Sukhpal Balmiki, my lord, third name from bottom.
TEC means temporary.
TEC means temporary. And my lord, there are three schemes we have. My lord. One is that OIPF. Second one is EPF.
So your scheme is you give this probation period once you confirm.
Lordship.
Continuous period means you bring him within the fold.
Lordship.
Then you put him into probation for 3 months.
3 months or 6 months. It cannot go beyond 6 months. And
So
my lord,
they
we have-
actually,
Lordship.
if we see page 8,
Hmm.
the affidavit, it is in these dates of 83, 82, 82,
Lordship.
they have been appointed.
Lordship.
And as the appointment happened here,
Hmm.
so the question of considering,
14-10-81 prior will not arise. That's all. it is. My lord, there are three schemes.
so
here.
yours therefore submission is that if this date of continuous period would have been as on 14-10-81 or prior also,
From my
this-
lord, the date of probation.
no, the serial number 4 at page 8. Not serial number, yes, it is on the 4th date of continuous service.
Date of continuous service. Yes.
So if it is before 14-10-81, then
Yes.
whenever the confirmation happens also,
make-
then he gets back to
He
this.
can make an application and get it. And my lord, we have three schemes. One is the OIPF, earlier one. Then the next is EPF, the Employment Provident Fund. And the third is that new superannuation. My lord, Employment Provident, the Employees Provident Fund pension is open to even a temporary employee. Because, my lord, they have to contribute and we contribute. That's under the Act, my lord. Any installation about 20, they have to. So, my lord, these people, when they were serving with us, they were contributing to EPF and we were also contributing. The other two funds, my lord, the employees don't contribute. It's the company that contributes through the trust.
And when did they raise this issue?
Raised this issue, my lord, just before, my lord, they came before this honorable court. I'll just place it, my lord. 2000, maybe, my lord, 2015 or thereafter, my lord. The first application is 13/1/2016.
At the time of retirement?
Just before that. And my lord, there is one more factor here. After their retirement, barring one, my lord, they have all applied for the benefits under that pension scheme. They have made applications. We have brought it on record. 114 onwards. Page 114 of the, my lord, affidavit.
Ah.
114, my lord. I hereby furnish the following particular payment of my pension. Kailash Valmiki, single life with ROC. Then, my lord, would see the next page. How the pensionary fund, my lord, that annuity, which is to be distributed 100% to his wife and thereafter 50-50. And accordingly, my lord.
All India Superannuation Benefit Scheme Fund.
Fund. That's the third one.
But this was done only in 2015.
Because that will be done when they retire, my lord. This is the claim they make. And my lord, with that scheme came, no. That scheme came
earlier.
1/1/2017 onwards. 7 or sorry, 1/1/2007 onwards.
What?
That scheme, my lord. Last one.
It says that you have to complete 15 years as on 1/1/2000.
No.
Huh? Yeah.
No. That's one of my also, my lord. First thing, but the
on roll as on 1/1/2007 and who had put in
15 years from the date in the 15 years service, my lord, in the company.
So he has to be enrolled
on
1/1/2007.
Lordship.
And who had put in minimum
15 years.
50.
Not after 2007, but the service before that also included.
So when did you come up with this scheme?
My lord, this scheme was introduced. I'll just give that. Lordship.
Sometime in 2007.
Round about that, my lord, yes. Can be availed by an employee who was on the rolls of the company as on so and so and who have put in minimum 15 years of service in the company at the time of his superannuation, who joined in the company after 1410. So on the date of superannuation, if he has more than 15 or more than years, then my lord, he will be under this. And here the prescription is.
Now, if the scheme has come in sometime around 2007,
Lordship.
What was the pension?
My lord, then my lord, it was the Employees Provident Fund pension. The second one. In between, there was nothing, my lord. Para 26, we have said that. And my lord, this new scheme came in 2013 with effect from 1/1/2007. But it covered all those people who came in after 1410/81. And the provision of the third scheme is that if you are enrolled in that earlier one, you will not get this. But that's my lord behind the point. It is there in page 70. But here they have taken the money also. And they are saying, no, we want OIPF. OIPF, admittedly, my lord, they don't fulfill.
Yes, Mr. Saikya.
Fine, my lord. These forms have been signed after their retirement. When they went to receive the pension.
No, we are not on the question of this, whatever you have done. The question, therefore, is fairly applied. Only question is whether you were employee of the company as on 14/10/19. That is the question.
Date of appointment, I have given all the dates of appointment.
But whether you can say a person who is there on temporary or an ad hoc basis can be said to be an employee.
Because for that may take a logic to the act provisions of the act by which this particular scheme has been inherited. It is there in the affidavit in opposition.
Page
55.
Huh? Page
55.
55.
55. The running page 55. Otherwise, affidavit in opposition page 19.
19.
19. In R1. Running page.
Okay. Got it. Manupatra.
They have annexed here.
Yes, 19.
Then these definitions are given.
You're referring to which one?
We come to section at page 23, section 11.
Transfer, yes.
Every whole-time officer or other employees. The word is every whole-time officer or other employees. These other employees includes all other employees. Of a specified company, which is specified company is the Burma Oil and the Assam Oil company. So who was immediately before the appointed day employed by the company in connection with its undertaking in India, and every whole-time officer or other employees of a specified company who was immediately before the appointed day temporarily holding any assignment outside India shall on the appointed day become an officer or other employee, as the case may be, of the central government or the conserved government company. The whole office or services under the central government or the successor government company, as the case may be, on the same terms and conditions and with the same right to pension, gratuity, and other matters as
were you at any point of time with this particular Burma Oil company?
This scheme, even the Oil India Limited, those companies, because it was initially at first it was a joint venture company. So Oil India employees were also drawing the benefit out of this fund. So here, the clause 1 and 2, it says those who are with the specified this company, this Burma Oil and Assam Oil company, those were either the whole-time employee or other employee, they will continue to get. And so far as subclause 2 is concerned, it is the whole-time employee or the other employee of the Oil India company. So on the specified date, that is 1410. So 1410, all these petitioners were appointed. Maybe temporary, according to them. But what I say,
No. If you read the entire thing, 11.1, this will only apply if you were entitled to pension in the earlier scheme. Were you entitled to pension at that point of time when you were there? That is the only question there.
but I would have been entitled.
No. Were you entitled to pension at that point of time when you were there prior to your date of confirmation, which appointment, which they are saying?
Confirmation is something that they want to make.
No, not on confirmation. They are saying that you have an appointment sometime in the year 1982. This is what they are saying. Prior to that, were you entitled to pension?
Yes, because I was appointed with them, my God.
No. Were you entitled to pension? Show me that. Then we allow you.
Subsection 2, subject to rule made in this behalf under section 22, every whole-time officer or other employees of Oil India who was immediately before the appointed day employed by it in India, or every whole-time officer or other employees of Oil India who was immediately before the appointed day temporarily holding any assignment outside India shall on and from the day continue to be an officer or employee of Oil India on the same terms and conditions and with the same right to pension, gratuity and other matters as are admissible to him immediately before that day, and shall continue to hold such officer unless and until employment under Oil India is duly terminated or until his remuneration and condition of service are duly adhered by the company. This is first part. They are entitled. Now you are looking kindly section 12.
No, but Mr. Saikya, kindly show me only one thing. Prior to the date which they have given in 1982, were you at all entitled to any pension or other retirement benefits? That's it. If you show me that, you get it.
For that, this Burma Oil pension, that scheme has to be, but here, they have
Why do you require all these things? First of all, your appointment, you know
Yes.
what has happened prior to that.
Yes.
At that point of time, whether you were entitled to pension. If not, 11.1, 11.2 does not apply. If you would have been, then you get the same benefit here. In fact, that is
So
done.
that's what, again, it has been said in the trustee. The Lordship has already.
Because again, these are all questions of trust deed or whatever way. These are mostly a scheme of amalgamations which takes place. And in these amalgamation, whatever rights which were there with the existing employees continues with the same with the transfer companies or whatever. If you have a right out there, this right will continue there. That's all. You show me only one thing as to whether you had the right for pension or whatever may be as per the whatever the old pension, not old pension, but Oil India Pension Fund at the time when you were there. That's all. If you don't have, then we have to go as per what the order has been passed.
But they are denying my Lordship query, I have understood, but they are denying on the basis of that I was not a permanent employee. And so far as this section 11 is concerned, what it says, the whole-time employee or other employee, those who are entitled, they will continue to get it, my lord. So far as the other two is concerned, my lord, the subsection 2 is concerned,
No, there might be a case where somebody who are other employee, even a contractual employee, there might be many things where a person, a contractual employee is given certain benefits. Just for example, the second scheme, which is there. Those benefits were given to that person concerned. Similar benefits. I'm not saying about the second scheme, but some benefits are given, whereby there is a contribution made by both sides. Now, pursuant to this amalgamation, this person should not lose that right. So, by way of this amalgamation or this arrangement, which is otherwise called, whenever the central government takes over the matter, they will also be getting the same thing.
Now, that's what, what I'm.
Well, here are two. A petition stands allowed, and bail is to be released on the basis of the conditions which have been mentioned.
Much obliged.
In lighter vein, I don't know about the other thing, but the petitioner has been a person for which the law in bail had developed. Right from 167 to order pass order taking into account the order so passed today, the judgment and order passed. The petitioner, the registry is directed to urgent certified copy. The learned counsel for the petition.
The judgment to this one prayer to be circulated to all the trial court, the judge. Because your lordship knows that day live and law also came. So
Let us
that's
see.
That's my
Understood,
that
but
is
let us
my
see
prayer,
what
I-
happens in the Supreme Court.
Obliged.
I also take account of, apart from what you have given. Today, I have taken note of the e-court services, more particularly to the Kamrup judiciary. to find out what has happened yesterday in the trial. Have incorporated it up.
Lordship, fine.
Because I think today it is fixed for further examination of the PW 49.
My lord.
In fact, Mr. Das, the roots of 436A was there prior to 1994.
Yeah.
And there was a bill being placed in the Rajya Sabha
It was clear.
in the year 1994, which is the Code of Criminal Procedure Amendment Bill 1994, which was placed in the month of May 1994. And the Supreme Court, while taking up the NDPS matters in that under trial matter, Supreme Court under trial, had taken a clue from that. And in spite of there being no law, had released these people in view of Article 21 as well as Article 14. Although the law only came on 23/5/2006. The order to my idea. Mr. Sakia, told me that you were appointed prior to that. Means not this. I mean, sense that you have been you became an employee. If you have not, being an employee and entitled to.
Yes.
Well, otherwise, no. If you have employee and entitled to any of these three funds, obviously one fund, the third one you can't be there. The second one, no.
They have given, but the distinction among these three funds are the first one where I am questioning for method. Here, I don't need to contribute anything. If 40% of the salary would be coming as a monthly pay. So far as EPS is concerned, EPS 95, that is.
No. Mr. Sakia, the modalities of these three schemes is not in doubt. As I could understand, the first is those people who were existing employees under the Burma Cell Company or whatever maybe. And further to those persons who were there, who were employees as on 14/10/1981. And also will encompass those people who were confirmed subsequently. Meaning thereby a confirmation pertaining to probation.
Is required. But here the trust
Now,
also-
did your right of confirmation arose earlier? As on 14/10/1981. That is the answer you give it. Did your right of confirmation happen on the basis of a subsequent appointment which they say was made in the year 1982? Or your right of confirmation arose earlier? That's the question. Isn't that Mr. Nair?
But that's exactly my assumption.
But, exactly, this trustee, the trustee itself governs everything. It speaks only the whole-time employer and other employees. Full-time employee and the other employee. It makes no distinction between the permanent employee or temporary employee. And now, those who are on the appointed day, those who are appointed by the company, and otherwise eligible for confirmation or membership, they'll be also entitled. So I have to make an application, and the trustee will decide whether I am entitled to or not. Now this application has been made, and they have now come up with the particular impugn order where it says, yes, because I am not a permanent employee, as on the appointed day, I am not entitled.
No, they are not saying. They are saying that your right you were not even an employee entitled to any of the schemes at the time of on 14/10 1981. The right to get into any of the schemes, more particularly the scheme number 1, arose only after you were appointed, and on the basis of that, subsequently you were confirmed after 3 months. That is their submission.
Prior to that, I was an
So
employee.
prior to that, whether you come within, were you entitled to this scheme?
So far as their contention is that, as because I was not a permanent employee prior to that, though I have been serving prior to the date of appointment, prior to the appointed date, I have been serving.
Mr. Sekia, if I put it in other words, whether they were permanent or temporary, I'm not concerned to that effect. I'm only concerned as to whether you were on the basis of that appointments which happened prior to 14/10 1981, were you entitled to subscribe to that fund? You tell me that only.
As per this trust deed, there's no eligibility criteria, but this condition has to be fulfilled, and thereafter only one can be confirmed as the member.
Let us see that trust deed.
So this is that.
Yes, got it.
Page 70, running page 70.
Page 51 of the affidavit, or running page 89.
No, it will be trust deed at page 34,
Page 24.
34.
Huh?
34.
34
Affidavit
of the
page of the affidavit.
Of the affidavit. 34.
Internal page.
The fourth paragraph on ultimately come to page 35, the second paragraph. And whereas in order to give effect to the
Yes. Whereas?
page 35.
Yes.
Second paragraph. And whereas in order to give effect to the provisions of the Acquisition Act in respect of the beneficiaries of the existing fund, so however that their right and benefits are in no way prejudiced or diminished, the company is obliged to establish the fund for the purpose of providing pension in accordance with the rules of the fund appended to this trust deed to the members of the existing fund and also to others who shall have been admitted as member of the fund. They have to admit that is the and
So,
the member
it will be given to the members of the existing fund
and who shall be admitted as
also
members.
others who shall have been admitted as members of the fund.
Yes. So then the rule starts, this trust rule at page 38. Here, page 39, the definition of member says, member shall mean an employee of the company, including a whole-time director who has been admitted as a member of the fund in accordance with the rules. So an employee who has been admitted as a member of the fund. Then you look at me, page 41, paragraph 4.
Yes.
The trustees shall decide all differences or dispute which may arise under the rules, either so as to the interpretation thereof, or as to the right and obligation of the beneficiaries, and the decisions of the trustees shall be in all cases be final and binding on all parties concerned, provided always that where such difference or dispute shall be related to income. So all the decisions, whether he is entitled or not,
অহা নাই ৰ। Then
Clause 4, Lordship has seen page 41.
Hmm.
It is the trustee who will decide all the disputes or differences or even the interpretation of the trustee consent. It is not the Oil India Limited who will decide. Then Lordship may come to page 43. An employee of the company, clause B. First is clause 8A, which they have also quoted in the impugn order. Employee who were members of the Burma Oil India Pension Fund will be automatically be admitted to the membership of the fund. Then B, an employee of the company as at 14th October 1981, who was not a member of the existing fund, but was otherwise eligible upon confirmation for membership under the rules of the existing fund, may make an application to the trustee in such form as may from time to time be prescribed by the trustee, and such application shall be submitted at the. So on application, if they confirm, then I'll be entitled to it. It is the trustee who will be doing it.
No, I've understood this. An employee of a company as at 14 October 1980, who was not a mayor but was otherwise eligible upon confirmation for membership under the rules. If I go as per the interpretation which you are giving, then any temporary employee who have been continuing till today, as of now also, but subsequently being given a permanent employment subject to confirmation and being confirmed would be entitled to.
This
Isn't that the
the confirmation or the permanency of the service, that is not visualized by this trust deed.
no, confirmation is being given.
Confirmation or membership.
No.
Yes,
Who upon
confirmation for membership under the
under the
rules.
rules, but was otherwise eligible upon confirmation. You have to read it. But was otherwise eligible upon confirmation for membership under the rules of 12.
For membership, not for an employee or in service. And they, in the impugn order, they try to say they have not disputed my appointment or service prior to the appointed day. What they say, these are temporary. They try to say that he has been given in probation sometime in 82, and thereafter, after 3 months or so, they have been confirmed. So they will be entitled only under this system. So that portion is that particular observation, that particular ground is not there in the trust deed. What it says, upon confirmation, and the employees, whether he is a temporary or he is a contractual or he is what, it is permanent. It is not been made any distinction here and there.
Therefore, I was asking you, do you have a right of confirmation in the terms with the temporary, being they are temporary? You have a right of confirmation, being a temporary employee.
The documents I have annexed to Lordship, can you see, Annexure A.
Annexure?
Annexure A, my lord. Since the date of my initial appointment, they have been continuously, my lord, these break in service they have been showing. These are basically to avoid section 25 probably of the Industrial Dispute Act, which says in a particular year or 6 months, this many days if continuously serving, then he will be entitled to permanency in the service. So this artificial service has been made, but otherwise they have been making a payment regularly, monthly, and this contribution have been made. Your lordship will kindly see this employee code number at the top on the left side. This from the first date of joining, that is 21st September 1981. With this code number, I have retired from service.
So this is 14th of October, before 14th of October.
Yes, 21 September 1980 and before 14th October 1981. This is one of the employees. There's some others are also given. Dates of appointment I have given. So they are not disputing that. Only thing is that these particular services cannot be counted because they are break-in services, they were temporary. So they will be entitled only upon confirmation. Well, these particular ground of confirmation and permanency, these are unfounded in the trust deed. They are trying to justify it from the standing order. It has nothing to do with the trust deed, because this is an inherited scheme, and the who will be benefited, that will be decided by the trustee themselves. Now, in the earlier round of litigation, also, this court had directed the secretary and the chairman of the trust to decide the representation. But now, this has been decided by someone else. Now, when they have said, that permanent service is required for entitlement under this particular trust deed, the burden is also on them to show that this particular provision, they can say that permanency is required. Otherwise, that will be without jurisdiction.
Where is your standing orders?
My lord would find it at starts at page 32, 33.
Yes.
Permanent worker is a workman who has been engaged on permanent basis. Includes anyone who has been confirmed in writing as a permanent workman after satisfactory completion of probation period of 3 months, and in no case for more than 6 months. And 3.4 is temporary workman.
Even this does not say that person temporarily appointed will not be an employee. Here, employee definition is not there, my lord. That only permanent persons can be, my lord, considered as an employee.
Now, Mr. Secretary, if you see page 33
yes,
of the affidavit, which they have filed.
Yes. Standing order.
Now you see permanent, it's okay, understood. Which permanent? After satisfactory completion of probationary period is a permanent. Now, 3.3 says probation. Probationer is a person provisionally employed to fill up a regular permanent vacancy for an initial probationary period of 3 months, but in no case for more than 6 months, and who has not been confirmed in service. Now, another category comes at temporary. We have been engaged for a limited period for work which is essentially of a temporary nature, including project work, or who have been employed for temporary increase in work of a permanent nature. So your submission is the trustee does not take into consideration a temporary or permanent.
Even your lordship.
But if we take that submission as you have submitted, if a person who is continuing as of now also can avail that fund?
Yes, if he was, as on that day, he was on employment, as on the appointed day.
So in 1981, if a person is a temporary and goes on temporary, and in 2011, he got his job. Whatever.
Confirmation.
Not confirmation, he got another thing which had been given by which he had become a probation.
Okay.
And thereupon after 3 months he gets. So by virtue of what you are arguing, that person will also come within it.
Well, since temporary service itself will come in, the confirmation or the permanency is irrelevant. Because these trustee or the otherwise, it does not make any distinction.
No,
Even
no,
the act
confirmation has a very relevant factor.
for the other service benefits, etc.
No, 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 no,
Yes.
no, 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 no.
Coming in.
As per this also confirmation is required. But the question is whether a confirmation has to be taken into account irrespective of a person working out there for a temporary for all this while and thereupon being given another work by which he has become a probationer and then confirm.
The process for making
So,
the
but
permanent.
confirmation, without that confirmation, the question of and giving you the benefit under B does not arise.
Here the confirmation under the this membership method is the confirmation for
It is not a
membership.
confirmation of membership. You kindly see, read the language. Yes, there is a comma type
Missing, my lord. There's a comma missing.
missing. Otherwise,
Eligible
eligible upon confirmation
For membership.
or membership.
Not for in service or for employment.
No, 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 no.
Meaning that
Upon confirmation for membership.
For members of the fund. For members of being a member of the fund, that confirmation is required. Not in service.
Okay, did
if
you raise that issue before the trustees?
Mine.
Did you raise this issue before the trustees?
Yes, in fact, this court had directed also in earlier under retention because my representation was pending, they did not dispose of. So I have come to this court directed filings is the one that is.
No, did you approach before the trustees?
We have applied for it. We have applied for, we have made the application. That is us.
For a decision of the trustees in terms with section 4.
For being membership, and thereafter we have submitted also my representation that was not disposed of.
No. Have you applied for before the trustees, which is required as per here? If we see
Yes,
number
secretary, we have made
four.
that representation of 16.
This number 4 at page 41.
Page 24, my lord.
Page 41.
Of it. Page 41 of the affidavit. It's part of the trustee.
Yeah. Paragraph 4.
Yes, the trustee shall decide all differences or disputes which may arise under the rules either as to the interpretation thereof. So,
have you applied?
Yes, that will find in my writ petition.
Yes. Where?
Page 24, madam. Trustee All India Pension Fund, second one. Third is Secretary All India Pension Fund. And in fact, the High Court had directed the trustee to.
No. This you are asking for this. Have you asked in terms with clause 4, which says, as regards any dispute or differences which may arise under the rules, either as to the interpretation. Go there, ask them.
My lord, it is.
That is a final. This is if you say that you want to come under this particular thing, whether it is there is a comma or not, why should this court decide? Go there, and it is final, isn't it?
My lord,
why should this court decide? You raise that issue before the trustee.
Then they'll have to give
this
the
is
third.
this is the issue
If
that.
they go back to the tribunal, the trustees now, madam, the benefits that they have got under the superannuation fund scheme, that has to be refunded back.
Yes, yes.
And then let
That-
them go, my lord.
We
No,
did
let
not, we
them-
did not apply for
That
it.
will be a decision. Why should
But
they
my lord-
refund and go?
But my
Let
lord,
them go and apply
apply.
before the
My lord, if
trustees.
my lord says, why not? Let them go and search. But my lord
And-
will only have page 39. That was missed out, my lord, when my friend was reading of the affidavit.
Yes, where? Members.
Q, my lord.
Huh?
Q.
Q.
P, sorry, my lord.
Shall be.
Shall be in continuous and unbroken service with the company as an employee and shall include the periods of authorized leave. Service shall also include service rendered with the erstwhile Assam Oil Company Limited. Now what they have done, my lord, they have never protested. 24, page 24 representation, there are, my lord, as many as 9 people. My lord will see the second paragraph. My lord. Whether they can now, my lord, permitted to go back to the trustees again. Therefore, we would like to pray before your honor to kindly look into the matter and grant the benefit of so-and-so who have already retired and also extend such benefit to those who are yet to retire on attaining superannuation age. As such, the matter concern our retirement benefit at an early action is called for. Mother Hans retired in 2012. Balmiki, D.N. Balmiki 2015, Kailash Balmiki 2015, D. Balmiki 2015, S.L. Balmiki 2015. Who were left out was 6, 7, 8, and 9. Others, my lord, when they were in service, they never approved. After the retirement, they are coming.
No, whatever may be.
Come on, my lord, that
It
my
is
lord
a
is making
question-
that.
Because if you see 4, it is a question of interpretation that trustee has to take.
Fine, my
Let
lord.
the trustee took it.
Fine, my lord, my lord, with us. I have no objection.
Let
I have
them
no
approach
objection.
the trustee, because
Fine.
you see, the reason why I'm saying that trustee is relevant, why should this court give an interpretation to that particular clause 1B?
Today.
Because as for me, the comma is missing.
Comma is missing.
Because the comma would make a hell of a difference.
Lordship. Otherwise also, but comma is missing. Comma would have been better for me, madam.
It would have been
Better
made
for
clear.
Hmm.
So I think the trustees are better because they are the authority to the
interpret that.
which
Cool.
is final.
Let them make an application, no issue.
Page 24, madam.
It's okay, but Mr. Speaker, I
No,
think
this
it's
is an
better off.
application before the trustee only, madam.
No, you have to
This is
ask
not
for the interpretation. That is the
interpretation.
problem which is happening. If we are going by the rules, he says something, he says upon confirmation with a comma, and you say with the actually confirmation as an employee, as a member.
But what I'm trying to based upon your lordship method, this is the application method based with the situation. I have made this application before the trustee. They did not act on it, so I had approached this court. This court directed the trustee to dispose of. Now this order has come up not from the trustee, someone else. So this order is in
Mr. Saikia, the first and foremost, that document which you have relied upon, or the page 24 document, is a request, it's a representation.
Yes.
It's a We are not concerned with the representation, seek for an interpretation and then thereupon claim the benefits.
It is
because here you see, if we are relying upon the trustee, it categorically mentions that the trustees is the final authority. Why the trustees should not decide that?
Yes.
Let the trustees decide this aspect. Well, I hope the trustees are there. Mr. Lyle, trustees are there.
Trustee, the trustee is there. It's been for the trustee. Trustees there.
Decide.
The difference of interpretation has come up just because the All India Authority has stepped into the matter, deciding the matter. If that order goes.
Why, no, Mr. Saikia, why should this court deal with it when there is an authority to decide?
That's what my submission is that, my lord, my submission is that, my lord, since the lordship has, my lord, accepted that trustee is the authority, so trustee should decide the matter. So under this, my lord, circumstance, the order, my lord, which has been passed by the Oil India is, my lord, without jurisdiction. So, and the direction already.
The direction is 4 and 5, my lord.
And direction from this court is already there to decide by the trustee. So therefore, that order will be set aside and this representation.
Mr. Saikia, how much am I going to tell you one thing? The direction which is there is for the purpose of consideration of a representation. We are not concerned with the consideration of representation. We are concerned with the interpretation of 1B. Let the trustees decide and come up, and their decision is final. And upon their decision, you may have, you may ask whatever relief you have.
Yes.
I think that is the best option.
Lordship will formulate that one, my lord, and
Yes,
let them
you
decide.
explain it to the trustees. This is it. They may interpret it. Out with the
My lord, that interpretation I had placed, my lord, if Lordship can place it on record also, my lord, if required.
My lord, what my submission, my lord, they have assumed a my lord, jurisdiction which is not vested on them.
Huh?
They have assumed the jurisdiction which is not vested on the IOCL to decide my representation. It was direction on the earlier occasion was withdrawn. So therefore now it is the Oil India, my lord, interpretation that permanency in service is required.
So you pick it up with them.
So my lord, when my lord, this order was itself without jurisdiction, my lord, that without consider, my lord, that will not be taken into consideration. So Lordship will formulate the point and put it trustee to decide. My lord, what he is submitting, my lord, there is a my lord, his interpretation should also be recorded, and because of that, this my lord, litigation has come up. Had they not assumed this jurisdiction and the trustee would have done it, my lord, this thing should not have come, my lord.
My lord, it was for respondent number 4 and 5. Respondent number 4 is the resident chief
No,
executive.
no, Mr. Sekia, let me put your submission. Let me put his submission.
Lordship.
And I will say that it relates to the interpretation of the rules of the trust. And the trustees are the authority in terms of its court. And as such, the petitioner shall approach the trustees for taking an interpretation as regards so and so on the basis thereof that the Oil India shall act on the basis of which. I think that is the best
Yes,
way.
yes.
Out with the senior counsel assisted by R.S. Mishra and Mr. UK Nayak, the senior counsel assisted by
K. Kulika.
All. For all the
appearing on behalf of the issue involved in the instant writ petition is as to whether the petitioners herein are entitled to the benefits under the Oil India Pension Fund, bracket OIPF, bracket close, or the Oil India Superannuation Benefit Scheme Fund, bracket OISPSF. Being aggrieved by an order dated 3/5/2016, by which the resident chief executive of Oil India Limited had held that the petitioner are not entitled to the benefit under the Oil India Pension Fund, but rather come within the ambit of the Oil India Superannuation Benefit Scheme Fund. The petitioners, being aggrieved, have approached this court under Article 226 of the Constitution. The issue involved herein relates to the interpretation of clause of the rules of the Oil India Pension Fund, and more particularly Rule 8B, which is reproduced herein under 8B, page 43 of Graphic page. It is the contention of the learned counsel for the petitioner that Rule 8B does not distinguish between a temporary or a permanent employee. It is the case of it is the further submission of the learned counsel for the petitioner. That when an employee of the company is eligible upon confirmation for membership under the rules of the existing fund, he has to be given the benefit under the All India Pension Fund. On the other hand, Mr. U.K. Nair, the learned senior counsel appearing on behalf of the respondent, submit that an employee would mean and that an employee in terms with section 8.1b, rule 8.1b of the All India Pension Fund would mean either an existing employee of the company as on 14th of October 1981 who was not a member of the existing fund, or a probationer who upon being confirmed as per the standing rules, standing orders of the Oil India Limited, could be entitled to membership of the Oil India Pension Fund. Taking into account that at this stage, this court finds it relevant to take note of Rule 4 of the Oil India Pension Fund, which categorically stipulates that it is the trustee who shall decide all differences or disputes which may arise under the rules, either as to the interpretation thereof or as to the right and obligation of the beneficiary. And the decision of the trustee shall in all cases be final and binding all parties concerned. Rule 4 of the Oil India Pension Fund, being pertinent to the issue, is quoted here and below. Page 41.
Yep.
Taking into account the scope and ambit of Rule 4 of the Oil India Pension Fund, this court it shall not be proper on the part of this court to give an interpretation to Rule 1 to Rule 8B of the rules without the trustees, taking a call as regard the interpretation to the said Rule 8B. Under such circumstances, the instant petition therefore stands disposed of. thereby granting liberty to the petitioner to submit a to make a request to the trustees of the All India Pension Fund, thereby seeking an interpretation to Rule 8B. Mr. P.J. Shaikar, the learned counsel appearing on behalf, senior counsel appearing on behalf of the petitioner, submit. How much time? 30 days? Submits that within 30 days, the petitioner shall do the needful. This court further directs they are not parties, na?
Trustees.
The trustees are the trustees parties.
Respondent 5.
Huh?
Yes, respondent 5.
Therefore, directs the respondent number 5 and direct the direct the trustees of All India Pension Fund who is represented in the instant proceedings to the respondent number 5 to decide on the interpretation of Rule 8B and as to whether a temporary employee would also come within the ambit of Rule 8B. This court further directs that in the event the said request is being made by the petitioners within the period as aforementioned, the trustees of the All India Pension Fund shall decide the same and give an interpretation and give their interpretation within a period of 3 months thereafter. It is further observed that in the circumstance, the interpretation is given in favor of the petitioners. The respondent authorities shall grant such consequential reliefs to the petitioners as required. It is further observed that in the circumstance, the interpretation so given is it is further observed that in the circumstance, the petitioners are aggrieved with the interpretation so given. The petitioners would be at liberty to approach, to liberty to challenge the same in an appropriate proceedings. I gave you everything which I could, nothing more than that.
But then they have to lordship in third scheme. There is a third scheme aspect of third scheme lordship. They have already applied in respect of third scheme.
Mr. Counsel, they applied in the year 2015, just before retirement or some after retirement. Don't make- And I'm only asking you to interpret. If your interpretation is there in your favor, he need not. Please. Yes. A motion to
Production list, item number 3, promotion.
Yes, what is your case?
Also, this is other pertains to recruitment of lot Mandal in the district establishment of Nalbari lots. One advertisement was.
You are challenging what?
Challenging lots.
Whereby the candidate with roll number as mentioned in the state order was convicted by violating the provision of clause 7 of the by the stipulated that 4% against the vacancy would be confiscated against the up state. Should not be issued right fulfilling the criteria. So you are concerned with clause 7.
7.
Where is clause 7? Let us see.
Page number 19. Let's.
Against each vacancy, 4 numbers of candidates will be constituted on the basis of marks obtained in the written test. So they have not done.
No, so 18 means 4 person means 72 they should have called, but instead of 72 they.
How many posts are there?
18 posts, Lordship. Page number 18, Lordship.
So they page number 18. How many posts?
Third column, Lordship.
18 posts.
Yes, Lordship.
So against 18 posts, they have to do 72.
Yes, Lordship.
So they have how many they have done?
52 they have called. Page number 49, Lordship.
RFW. What is RFW? RFW is what?
Lordship is referring to
Page 18.
page 18.
Don't know exactly.
Financially weaker section. Reserved for financially weaker section, that is nil.
So 5. It seems you have not done for OBC, MOBC, because then I think it matches. 13 is 13/4 is 72 or 52.
Hello?
13 into 4 is 52.
Yes. No, Lordship, they have not differentiated as such. Lordship.
Huh?
They have not differentiated.
Where is the select list?
At page number 48, Lordship.
48. The candidates with the following roll numbers have been found eligible for appearing in the so for the post of last month with the declared as roll numbers are yes. Why have you done that?
So, my lord, at this stage, my submission will be, my lord, as per clause 7, total number of vacancies, my lord, 18. Against 18, my lord, 4% is required to be called. If I read clause 7, against each vacancy, 4 numbers of candidates will be shortlisted on the basis of marks obtained in the written test. We do not know, my lord, what marks they have obtained. Now, my lord, on 27, the computer proficiency test is scheduled. It is as per the, my lord, the select list. So at this stage, my lord, we have to have the instruction.
Mr. Borbuzari,
My lord.
you have instruction. Tell me, but why another 20 has not been? How many candidates have applied? Maybe 52.
No, according to them, Lordship, 136.
Huh?
136 candidate.
And 36.
136.
So you thought that you would have been there, nah?
Yes,
With the permutation and combination out there.
How many persons have applied, my lord? That is not discernible, my lord.
Chalo, we'll have it tomorrow. When is the next date?
Monday is the computer proficiency test.
Okay, no problem. We can state also on Monday.
At 9 a.m. Lordship.
Huh?
The test is to be held at 9 a.m. coming Monday.
No, because Lordship will kindly appreciate where 52 candidates have been called. It is their case if 72 candidates are called. If 72, what is the guarantee that they will also come? They will come within the ambit of that minor deficiency. 52, 62, 72. That means minor 20 persons is minor. There is a deficiency of 20%. But how they can say that if at all minor,
they may
20%,
come, may not come.
20% are also minor included, they will figure out. But that is my respectful submission. Secondly, my lord, if this process is stayed by this honorable court, this person will be affected, my lord. The whole recruitment process will come to a standstill, my lord.
Lordship,
So,
I am not
Lordship,
saying
at
for-
this stage, my lord, in my respectful submission, Lordship will not interfere. Let us have the my lord instruction. Let us have the instruction. Lordship will issue a short notice. Let this my lord recruitment process go on. Tomorrow, if my lord Lordship from the instructions, if it is found or from the records that you ought to have called 20 more, and they could have figured out in that 20. Definitely, my lord Lordship will give a my lord.
Tomorrow is the holiday.
Leverage to them, my lord. Lordship will pass an order accordingly, my lord.
If court proposes to do it, you go ahead. Whatever you do, but don't pass any final order.
Yes, Lordship will.
You go and on 27, let these 52 come out. There's no problem with that. On 27, why not another 20 if not possible?
Lordship may also do one thing, Lordship, let this petitioner also appear in the computer proficiency test on Monday. I am not praying for stalling the process, Lordship. Let this petitioner also appear in the.
Mr. Counsel,
We do not
you
know, my
kindly
lord.
don't make unreasonable requests. Think it. Why will this court allow you to participate when your name is not there? Tell me. Isn't it the requirement that you have to get a particular amount of marks in the written test? How are you sure that you have got that marks?
Lordship, in the advertisement, there is no
Mr.
part of.
Counsel, only thing what is required is let them go ahead. Let them hold the meeting on it. Okay. But on that day, they will ask them, why not call another 20? Let them call for another 20. That is the only instruction we require. This court doesn't want to stay the procedure, recruitment process. Let it be there. But it shall not affect your right to that effect. Yes, what is your name?
A.D. Chaudhary.
Mr. A.D. Chaudhary, the learned counsel for the petitioner. You are finance?
Revenue.
Also revenue. Mr. R. Pujari appears on behalf of the respondent number 1, 2, and 3.
Only one, my lord. 2 and 3 months.
The R appears for respondent number 2 and 3. Mr. Third, you are causing the problem. Is it at your instance? Issue notice making it returnable on 27/2/2027, 3/2023. The learned counsel for the petitioner is directed to serve extra copies of the writ petition during the course of the day. Serve it. As the respondents are duly represented, extra copies of the writ petition be served upon them during the course of the day. Issue notice returnable on 27/2/2023 at 2 p.m. As the respondents are duly represented, extra copies of the petition be served upon them. The case of the petitioner herein is that the petitioner pursuant to an advertisement dated 1/3/2023 issued by the Deputy Commissioner Nalbari had participated in the said selection process. It be mentioned that in terms of the said advertisement, the post to be filled up is 18 numbers of sanctioned vacant posts of Latmandal Group 3 under the amalgamated establishment of the Deputy Commissioner Nalbari. Amongst the various conditions in the advertisement, clause 7 categorically stipulated that against each vacancy, 4 numbers of candidates will be shortlisted on the basis of the marks obtained in the written test. It is the case of the petitioner that on 22/3/2023, an order has been passed by the Deputy Commissioner and Chairman Selection Committee, Nalbari, whereby they have shortlisted (52) candidates on the basis of the written test in pursuance to the advertisement dated 1/3/2023. The Learned Counsel for the petitioner submits that as the petitioner is an aspiring candidate, his fundamental right to be considered have been affected in as much as 20 less candidates have been shortlisted. The advertisement dated 1/3/2023. The Learned Counsel submits that the said selection proceedings needs to be stayed forthwith. I've also heard Mr. R. Borpuzari, the Learned Counsel for the Revenue Department, as well as Mr. R. Dhar, appearing on behalf of the respondent number 2 and 3. It is the submission of the respondents that derailing the selection proceedings at this stage would affect the administrative exigencies, taking into account that by the order dated 22/3/2023, already those persons who have been shortlisted have already been called at 9 a.m. on 27/3/2023. The right of the petitioner to challenge the selection proceedings have also been questioned on the basis as to how the petitioner could be so sure that he would come within the next 20, would have come within the 72 selected, that would have come if 72 names were shortlisted. I've given my anxious consideration to the matter. This court is not inclined to stay the process in terms with the order dated 22/3/2023, meaning thereby that the office of the Deputy Commissioner Nalbari shall proceed with the process in terms with the order dated 22/3/2023. It is, however, observed that no orders of appointment shall be made till the next date. On the returnable date, the office of the Deputy Commissioner, as well as the Department of Revenue, shall apprise this court as to why there has been no compliance, there has not been any, why only 52 candidates were shortlisted and not 72, as is required under, as is otherwise required under clause 7 of the advertisement dated 1/3/2023. List record.
My lord, humble prayer, my lord. My lord, can it be on 28? My lord, they are.
Can I stay the entire thing?
No, my lord, tomorrow and day after tomorrow is whole day, my lord. Officers are closed. Monday only I'm getting time, my lord. That is only if.
That is why I said to give a call to these people why they have done. I'm not asking, these are all done, everything. Give a call to these people. If this was done in the morning, I would have taken up at 2. But this is taken up 3, that is why I can't take it at 5. You want, I can take it up at 5. Get the information. I won't disturb you on 27. But you.
My lord, a copy of this order may be on it. I will, if it is uploaded, I will, it will help me. Copy of the order.
Are you saying that the Deputy Commissioner won't hear what you are saying? And otherwise show him the live stream. What happened?
Obliged.
Yes, Mr. Barbuzari. In this case, this person concerned, you have issued an inquiry report
Yes.
on 14/7/2022.
Yes.
14/9/2022. In the inquiry report, which is there, you see, where is it, Mr. Counsel?
At page 39, Lordship.
Page 39. Yes.
39.
Kindly come to page 40.
40, yes.
Inquiry conducted for so and so. During inquiry, so and so has submitted the documents which were found in the year 2010. He has produced the registration form, but could not produce any other relevant document. During inquiry, he could not produce his official seal rubber stamp as per his new jurisdiction area. He is still working the old official seal as per earlier. During inquiry, it is found that so-and-so has lack of knowledge about his official duty and Muslim marriage registration and role of Trustee. He has also mentioned that he is quite old now and difficult for him to serve his duty. During inquiry, he has denied to submit any statement. He has submitted only attendance in presence to his engaged counsel. In view of so-and-so may not be considered act as a party in the interest of so-and-so. Now you see his show cause, what you have asked. Where is that? Where is the show cause?
Page 38.
Huh?
38.
Page 38. Yes. What you have asked him? The second paragraph. So the so-called you have asked is in respect of something else, and the findings of the inquiry is in respect to something else.
Yes, of course, my lord, it is there.
And Lordship, suspension order speaks something different. Suspension order also speaks something different than that of Lordship inquiry.
So first notice, my lord.
Mr. Barbujari, I have dealt with this matter earlier in detail. That is why I know. I gave him the liberty and asked him on the last occasion that why don't you file a separate writ petition? Because what you are asking, he had only challenged initially 16/7/2022. That is the order of suspension.
Yes.
Thereafter, in the order of suspension, if you see, it has been done pending drawing up of departmental proceeding.
Yes, my lord.
Now, the departmental proceedings concept is totally foreign out here. Here is a case of a show cause. Because if you would see the 18, what Act of 1860, 1880, more particularly Section 2,
Section
stipulates that there is a power of removal as well as suspension. Power is there. When that in terms with such things, which in terms with the said provision, what is there is only a show cause.
Yes.
But it is an established principle of law that when you issue a show cause, you have to issue the show cause on the basis of what you want.
Yes.
And it can't be on the basis of something else.
Yes.
There was no show cause to that effect that he has to bring the seal or whatever maybe, and nothing to that effect. Then on what basis does he say that he can say anything to that effect?
I'm just trying to locate the show cause notice. That's what
This
my
is
lord.
it. Page 38.
Page 38.
Ah.
Page No, it is not telling with my place. Therefore, my lord, I'm getting it. It is here. Actually, here it is. That day also one matter came up, my lord. Therefore, my lord, I know. It's 39 in my copy.
Okay.
Here.
38, 38.
Here it is, my lord. It is supposed to. This office earlier letter. I am to inform that you have been asked to appear before me on 25th May 2022 at 11 a.m. for discussion on functioning of MMR Kazi on various issues relating to so and so. But you have failed to appear before me in the stipulated time and date against when inquired, and it was later found that you had been absent from the district for last 4 to 5 days without taking permission from Deputy Commissioner, who is also the district registrar. Hence, you are ordered to submit a reply to show cause as to why disciplinary action should not be initiated for this subordination. It should be insubordination and be present so and so, non-appearance will be viewed seriously. Now here, my lord, what transpired from this document is that, my lord, he was in unauthorized leave for 4 to 5 days. This document also mentions about earlier letter, my lord. Might be, maybe, my lord, I am not aware. Maybe, my lord, detailed allegations might have been there, my lord, in these letters. I do not know.
No, but here the subject matter is the show cause.
It is, though, my lord, it is worded as so cause, but here, my lord, the tenor of
There is mention, but whenever the records was produced in the earlier round, there is nothing to the effect. What has happened, he has been suspended on another ground. You see this. Kindly see page 33.
33, my lord, yes. Here is the proposal for suspension revoked from service of so-and-so, whereas it is observed that Azahar Ali, Qazi so-and-so have violated Rule 5 of divorce and so Muslim marriage divorce rule by violating jurisdiction, leaving headquarters without permission of the concerned authority, and not submitting copies of registration of marriages as well as monthly return to the district register. As such, in exercise of the power delegated under so-and-so, so-and-so is hereby placed under suspension with immediate effect for gross insubordination and indiscipline in complying the order of the district register South Salmara issued by letter number so-and-so dated 20 May 2022 and 26 May 2022.
And failing to receive the so-called issued on
26 May. Now, this document makes a reference to these two letters. Makes a reference to these two letters. Now, the difference between my lord, this order of suspension and this so cause is that, my lord.
No. These 26 May, down below the 26 May, which is the reference is,
My lord.
here, page 38. Page 39 in your.
Yes, page
That
39.
is 26 May.
Yes,
This was given on 16/7. This is on 26 May.
yes.
Now 26 May, you have asked him for unauthorized absence. But what is this inquiry where you have found something else? We have not gone into the question of unauthorized absence.
No, my lord, these are the documents which he could not show because he says that he was
Understood. If he could not produce those documents or whatever may be, the proposal was issued on 26/5.
Yes.
26/5 does not say anything about producing any document.
No, it doesn't say. It speaks of only, my lord, unauthorized absence. Now, to justify.
And leaving the jurisdiction without permission.
Yes, now to justify the fact as to whether he was unauthorizedly absent or not, my lord, he has to produce the documents. So therefore, my lord, those documents are produced. It is not that he was not given a hearing. He was given a hearing, my lord.
No. If you issue a show cause in respect of something else and the finding is something else, how can you?
No, finding, my lord, yes, finding, I'm reading it again, my lord. Inquiry conducted for Azhar Ali. During inquiry, Mohammad Azhar Ali so-and-so has submitted the documents which are found in the year of 2020. He has produced only registration forms but could not produce any other documents. During inquiry, he could not produce his official seals, rubber, etc. He is still working in the old office seal rubber stamp so-and-so, violating the order of IGR. During inquiry, it is found that so-and-so have lack of knowledge about his official duty and Muslim registration in the role of Qazi. He has also mentioned that he is quite old now and difficult for him to serve his duty. During inquiry, he is denied to submit any statements. He has submitted only attendance in presence of his engaged advocate.
You want to issue a show cause, do a show cause properly because the power is given. Although you don't require to have a departmental or disciplinary departmental inquiry, not required as per section 2. Not required. The power is given to suspend as well as to revoke the license. This is a license of the Qazi.
I got it. My only difficulty is, my lord, this so-called notice is not happily worded. This so-called notice is not happily worded. It could have been, my lord, little, because this.
No, what we do, we state this inquiry report. I'm not doing anything else. Inquiry report, giving you the liberty to initiate show cause properly.
Yes.
I think that is a better option.
I'm so grateful. Yes. Sir. But a message should go to the, yes, a clear message should go to the authority.
Mr. A. Islam, the learned counsel appearing on behalf of the petitioner. And Mr. R. Baputari appears on behalf of the respondent number 1, 2. Hardhor appears on behalf of the respondent number 6. Why you are making the inquiry officer party?
The inquiry officer.
Inquiry officer, there is no malafide against it. The malafide is against these three persons, not 3, 4, and 5.
So what is stated in the so cause notice? There's not a single whisper in his.
Understood, but can you allege malafide against them? No. I understand your point. As per the facts, if I remember correctly, at that point of time, you were given a particular jurisdiction as Qazi. After being working as a Qazi, there was another person who were appointed. You challenged it, and the court set aside his appointment. And thereafter, they did not comply for a year. And after having not complied for a year, you filed a contempt. Then on that after 2 days or 3 days, they came up and said that, look here, we have already cancelled it. And after cancelling, what they did, they have reduced your area or made it given you some area, other area. And thereafter, you have been suspended. Isn't it? Well,
Yeah, Lordship, I want to make one thing clear, Lordship.
Why you are making the inquiry officer? Don't make. We strike off. Number 7 not necessary. Okay, 3, 4, and 5 it's okay. But 7 is it is. Majumdar, I don't think it is required for that.
Yes, your Lordship. One thing, Lordship, I would like to make clear.
Yes.
The Kazi Act, 1880 Kazi Act governs the ritual done by the Kazi. The ritual aspect is governed by the Kazi Act, 1880. And the registration part, Lordship, it is governed by the Assam Muslim Marriage and Divorce Registration Act 1935. What they are referring section 2 of the Kazi Act 1880, Lordship, that Lordship, that covers the ritual part when the marriage is solemnized. During solemnization, marriage ritual has to be done by some Maulana, Lordship. That part governed by the Kazi Act 1880. But in registration part, Lordship, that is governed by the Assam Muslim Marriage and Divorce Registration Act 1930. What they have done, Lordship, in their suspension order, they have never mentioned my license number. They have never mentioned. They only suspended me. Why they have suspended me? In contemplation of a disciplinary proceeding, Lordship.
Which cannot be there.
It is disciplinary proceeding, Lordship, totally is foreign to the Islamic jurisprudence, Lordship. It is unknown to the Islamic jurisprudence. They can't do that things, Lordship. But Lordship, my humble submission before our Lordship is that a thing intended by a legislature to do in a particular way, that has to be done in that way. This is the established principle of law. What they have done, they have suspended me in contemplation of a disciplinary proceeding. And for that reason, Lordship, I am, Lordship, subject to social stigma and scorn, and that is, Lordship, I am difficult to lead a dignified life in my society. And that is clear violation of Article 21 of Constitution, Lordship. And they arbitrarily deprived me from my livelihood. That is also, Lordship, is a violation of Article 19G of Constitution, Lordship. And other 2 and 3, Lordship, other 2 and 3 cases, they are similarly situated. They are also, Lordship, having same charges, but they have not taken any action against those cases. Only they have taken action against.
But Mr. Counsel, one thing. If you see section 2 of the Kazi Act, do they not have the power to suspend you?
They have power, but as regards performing of ritual during marriage, Lordship, as regards performing of ritual by me, Lordship, I also perform rituals when marriage solemnized. And at the same time, I also do the registration part also. And the registration part, Lordship, governed by section, Lordship, section 3 of the Assam Muslim Marriage and Divorce Registration Act 1935, section 3, Lordship.
You have a copy of it?
Lordship. Lordship, kindly have a look at section 3 of the Act, Assam Muslim Marriage and Divorce Registration. Lordship. Section 3, Lordship. May I read, Lordship?
Give it to me. Now, in your case, there are two persons in the same area, no?
Lordship,
Oh, no, they bifurcated it.
bifurcated. Yeah. Absolutely bifurcated.
So what I have,
But what do you say, Mr. Counsel? The power to appoint also includes the power to remove and suspend.
Exactly, Lordship.
Then why there is no power to remove or suspend in terms of
What?
Section 21 of the General Counsel?
What they stated in their suspension order, Lordship, in contemplation of a disciplinary proceeding. In contemplation of a disciplinary proceeding, I am suspended, which dehodes any known provision of law, which dehodes any known provision of Islamic jurisprudence. Lordship. In contemplation of a disciplinary proceeding, I am suspended.
But you see, the appointment is only to be given to a Muslim. That is the only qualification. There is no other qualification for appointment.
Exactly.
As per Section 3, shall authorize him to register Muslim marriage and divorce, which have been effected within certain limited areas on the application name. So the power to grant you are only given a power license. So that is the only license which have been. The moment that there is maybe the question of granting a license.
My point is the Lordship, why disciplinary proceeding against me, Lordship?
No, there is no disciplinary procedure. No,
In
there is.
suspension order, Lordship, they have stated.
Huh?
In suspension order.
Understood, but that cannot mean to be a disciplinary proceeding.
yes, I was about to make that submission.
Concept of it is not a question of disciplinary proceeding, but the power to appoint includes the power to suspend.
Yes, here Lordship will kindly see, my lord, the provision. First, if my lord is taking up that Act of 35. Act of 35. 35, my lord. Section 3 says, my lord, state government may grant license to register. This is the enabling power, my lord, enabling provision. The state government may grant a license to any person being a Muslim, authorizing him to register Muslim marriages and divorces which have been effected with certain specified limits on application being made for such registration, and may revoke or suspend such license. And now here, pending disciplinary proceedings, my lord, it is not qualified with such. Lordship, I am making the submission. Lordship will kindly come, my lord, to the rules. Rules, my lord, under the Act of 35. Lordship has seen the enabling provision, my lord, at Section 3. Now the rules. Lordship will kindly see, my lord, Rule 8. Rule 8 of the, my lord, Assam Muslim Marriages and Divorce Registration Rules 1935, Rule 8. The Inspector General of Registration may ensure, suspend, and may make transfers and postings of Muslim registers. When possible, he will conduct the permanent committee. He will consult the permanent committee. So the power is there. Then my lord will kindly see, my lord, the Qazi said.
That also is parameter to Section 2.
Now my respectful submission is where nowhere under the statute contemplates for holding any disciplinary proceeding. Per se, my lord, I am not satisfied, I can suspend him. Per se, without going, my lord, or without adhering to the principles of natural justice. This is what, my lord, the statute contemplates.
Now you can suspend, but can you keep him under suspension for a long time? I'm not on Ajay Chaudhary or anything to that effect, but can you keep it? Because if you keep the person under suspension, being a state authority, wouldn't it touch upon the fairness of the action of the state authority?
But my lord, the statute does not, my lord, prohibits. Statute, my lord.
Isn't it the well-established principle of law that Article 15 is already there? The concept is already there. The fairness of action has to be there. So you have to take a decision.
Also, departmental inquiries have already been completed.
Where is the departmental inquiry?
These are all redundant exercises done by my officers. Therefore, my lord, I am facing all the difficulties.
Further continuation.
These exercises should not have been done immediately, my lord. Because there have been complaints, my lord, public complaints against the petitioners, my lord.
Here
On
also,
the
Lordship,
basis of which, my
regarding,
lord,
regarding
they-
public complaint.
No, if there is a public complaint against the petitioner, no problem. You take a action out there.
That's what, my lord. That's
You
what-
take action on, put him to notice what public complaint you are doing.
No, that's what, my lord, in the earlier round of litigations, my lord, because this might be, my lord, the 6th or 7th round of litigation. But there are so many litigations in the name of the petitioners, my lord. I will not comment on that right now. Now, there are, my lord, public complaints time and again, my lord. Time and again, there are public complaints. Now, this exercise ought not to have been done by the, my lord, state authority. They could have simply said, then these are the answer, you are suspended. And if you have something to say, you say, otherwise, my lord.
That's all.
Yes, at the end of the day, you are.
But let him know what he is charged of.
They have all, my lord, distracted the.
So my learned brother, talking about the public complaint, in this regard, Lordship, if Lordship allow me, I kindly. Lordship, is 35 Lordship.
Okay. Heard Mr. A. Islam, the learned counsel. We protect you as regards we know the reason why I'm protecting you, because there is an impediment that these people are going to terminate you. That is why I'm protecting you against it. On the last occasion, didn't he produce that document? Mr. T.C. Zutia.
Lordship will make some observations in my lord, so that I can persuade my lord. Because the message should go to the authority.
But Mr. Spencer, the learned counsel appearing on behalf of the petitioner. Mr. Arbo Pujari appears on behalf of
R1 and 2. R1 and 2.
1 and 2. Mr. Ardhor appears for the respondent number 6. The learned counsel for the petitioner at the outset submits that he does not want to proceed with the respondent number 7, and accordingly the name of the respondent number 7 is struck off. Issue notice making it returnable on 10th of April 2023. As the respondent numbers 1, 2, and 6 are duly represented by the respective counsel, extra copies of the petition be served upon them during the course by Monday. As regards the respondent number 3, 4, and 5, steps be taken by way of registered as well as usual upon the said respondents by Monday. The case of the petitioner herein is that the petitioner was appointed as a Qazi, was appointed as a Muslim marriage register as well as Qazi under the provisions of the Assam Muslim Marriage and Divorce Registration Act 1935 as well as the Qazi Act 1880 respectively. While the petitioner was operating in a particular area, who was the person?
Abdul Kalam.
Huh?
Muhammad Abdul Kalam.
One Mr. Abdul Jalal.
Kalam.
Huh?
Kalam.
Abdul Kalam was appointed as the second Muslim marriage register and as well as Qazi in the same under the same jurisdiction of South Salmara Police Station. The petitioner challenged such appointment, such action of the respondent. In WPC number 2029, public 2020. The order by which the said Abdul Kalam was appointed as the second Muslim marriage register as well as Qazi was set aside by this court by the order dated
27/1.
27/1/2021. And then by which he was appointed, that is by notification dated 6/1/2020. Was set aside by the judgment and order dated 27/1/2021. However, it appears that the said order passed by this court dated 27/1/2021 in WPC number 2029/2020 was not complied with, for which a writ petition was filed, for which a contempt proceedings was filed, being contempt C number 396/2021.
22, Lordship.
What?
21. 21.
This court in the said proceedings by an order dated 17/12/2021 issued notice as to why contempt proceedings should not be initiated against for not complying with the order dated 27/1/2020 passed in WPC number 2029/2020. In pursuance thereto, the additional secretary to the government of Assam Revenue and Disaster Management Registration Department by an order dated 12/1/2022 had cancelled revoked the license dated 6/1/2020 issued in favor of the said Abdul Kalam by the same order. Another license was issued to the said Abdul Kalam for the jurisdiction of Haruabonda OP area under South Salmara, Mankasa. On the same date, another notification was issued on 12/1/2022, whereby the jurisdiction in respect to which the petitioner was earlier exercising pursuant to his appointment as Muslim is registered and Qazi were changed, and a new area of jurisdiction for registration of Muslim marriage and divorce was allotted to the petitioner, that is Tuksar Police Station area under South Salmara, Mankasar district. It further appears that pursuant to those orders on 12/1/2022, being brought to the notice of this court in contempt petition number 396/2021. This court, by an order dated 27/7/2022, instead of dealing the said aspect in the said contempt jurisdiction, gave the liberty to the petitioner to file an appropriate petition against such notification if it violates the legal right of the petitioner in any manner. It is the further case of the petitioner that in view of filing of the said proceedings, a suspension order was passed on 16/7/2022 by the Inspector General of Registration, Assam, whereby the petitioner was suspended pending withdrawal of disciplinary proceedings. The learned counsel for the petitioner submits that Departmental disciplinary proceedings is completely foreign to the provisions of the Qazi Act 1860, as well as the Assam Muslim Marriage and Divorce Registration Act 1935. It further appears that on 26/5/2022, a show cause notice was issued by the Additional Deputy Commissioner South Salmara to the petitioner, asking him to show cause why he had failed to appear before him on stipulated time and date against, and upon further inquiry, it came to learn that the petitioner was absent from the district for 4-5 days without taking the prior permission from the Deputy Commissioner, who is also the district registrar of the South Salmara, Mankasa. The petitioner was therefore asked to submit a show cause reply as to why disciplinary action should not be initiated against him for his insubordination. Thereupon, it further appeared that an inquiry was made by the Additional Deputy Commissioner, one Dr. Hitesh Majumdar, whereby it was opined, and whereby, as per the inquiry report dated 13/9/2022, it was opined that the petitioner may not be considered to act as the Muslim marriage register and Qazi in the interest of public. The reasons assigned therein were the petitioner had submitted certain documents which were found to be of the year 2020. And he had produced only registration form but could not produce any other relevant documents. It was also opined in the inquiry report that the petitioner could not produce his official seal, rubber stamp, etc. as per his new jurisdiction area. And he was still working with the old official seal, rubber stamp in his earlier jurisdiction area, violating the official order of the IGR and the government of Assam. It further appears from the inquiry report that it was found that the petitioner had lack of knowledge about his official duty and the Muslim marriage registration and the role of Qazi. And the petitioner have also mentioned during the inquiry that he is quite old and difficult for him to serve his duty. It is on the basis of the said findings the opinion was given in the inquiry report that a petitioner may not be considered as a Muslim marriage register and Qazi in the interest of public. In the meantime, the petitioner have been approaching the respondent authorities seeking for restoration, for reinstatement, and for cancellation, and for modification, and for cancellation of the suspension order dated 16/7/2022. Having nothing, as there was nothing, as there was no response from the respondents, the petitioner was compelled to file a writ petition, that is WPC number 5483/2022. While the said writ petition was filed, there were various pleadings and documents which were placed on record. And from the documents, it revealed that there was a show cause notice which was issued to the petitioner. And there was this inquiry report dated 13/9/2022, which the petitioner submits that he had no knowledge about the same. Taking into account that there were various developments which had ensued after the order dated 16/7/2022, by which the petitioner was put to suspension, liberty was given to the petitioner to approach this court by bringing into account, by bringing on record the necessary facts. It is under such circumstances the instant writ petition has been filed by the petitioner. Next. This court had perused Section 3 of the Assam Muslim Marriage and Divorce Registration Act 1935, as well as Section 2 of the Qazis Act 1880. From a perusal of both the provisions, it transpires that the state government has the right to appoint, as well as also have the right to revoke or suspend the license. The concept of disciplinary proceedings, as from a perusal of both the acts, is completely foreign. However, the right of, taking into account that the principles of natural justice is embedded in all statutes, this court is of the opinion that it is necessary that before termination or before cancellation or before revocation of the license, it is required that there has to be a show cause proceedings. However, if this court takes into account the show cause which was issued on 26/5/2022 enclosed as Annexion 9 to the writ petition, it shows that the ground on which the show cause was issued is completely different from the reasons mentioned in the inquiry report dated 13/9/2022 submitted by the Additional Deputy Commissioner South Salmara. Considering the above, this court is of the opinion that the inquiry report dated 13/9/2022 is required to be stayed in the interest of justice, and accordingly, this court stays the inquiry report dated 13/9/2022. Now, coming into the question of the suspension order dated 16/7/2022. There is no quarrel with the fact that the authority who has given the appointment and has, no, there is no quarrel. From a perusal of Section 3 of the Assam Muslim Marriage and Divorce Registration Act 1935, as well as Section 2 of the Qazi Act 1860, that the authority concerned has the power to suspend. However, it also needs to be taken note of that when a suspension, when the period of suspension goes on for a long time, it becomes onerous and punitive. It also touches on the fairness of the action of the respondent authorities. Under such circumstances, this court, though not inclined to stay with the suspension order, but directs the respondent authorities to take appropriate action pursuant to the suspension order. Forthwith. The learned counsel appearing on behalf of the respondent, Mr. Mr. Arbab Pujari, shall apprise this court on the next date upon instructions as to what steps have been taken pursuant to the suspension order.
One more provision, my lord, under the Act of 35, every Muslim marriage register is a public servant. So therefore, my lord, that he is entitled to some.
Yes, but what is being given to him is a license.
Yes, yes.
It is not his services.
Yes, exactly. There lies the difference.
That is why I am saying
Yes,
that it is a question of only show cause. The principles of natural justice come. You take whatever steps you want. Do something by 10th of April. We need to know.
My lord. I'm so grateful, my lord.
Deeply.
My pleasure, Lord.
Yes, secondary
the
education.
verbal
What have you got?
Lordship, the verbal instruction that we have received is that he has been appointed against the sanctioned vacant post. That was the query
Whether
that
the
was sought for.
petitioner's appointment was against the vacant sanction post.
Lordship.
Then
But then his salary was stopped, Your Lordship, from February 2007 till date. He has not received his salary, Your Lordship.
Then why are you not paying? When you are paying?
Lordship, in fact, the inspector of schools, they have sent the proposal for giving him the area salary. It was sent on March 2022, Your Lordship. And then what I had, they had the instruction that they have given me is that the director of secondary education, they have again sent the proposal and they have asked for some detailed report, Your Lordship. Because detailed report on why his salary was stopped, Your Lordship. On that, they had asked for detailed report.
For that further, are you going to put the petitioner to agony?
Lord.
Are you now presently? Are you getting anything or not?
No, my.
It's not.
Then I'll fix it in the month of May.
Lordship.
8th of May.
Lordship.
You do something else. We are going to impose this interest upon you, and which shall be deducted from the salary of the hearing officials.
Lordship.
I think that is a better option.
Lordship.
Heard, Mr.
M. Islam.
M. Islam, the learned counsel appearing on behalf of the petitioner. Ms. D. Musari appears on behalf of the Secondary Education Department. You are appearing?
Yes, my lord.
Mr. Arbobaji appears on behalf of the
Finance, my lord.
Finance Department. The claim of the petitioner herein is that the petitioner was appointed against the sanction vacant post. And the petitioner still continues
Yes, Your Lordship. And in
to
fact, next
render
claim is that-
service. Where?
My lord, in Gandia High
Gandia
School,
High School.
Gandia High School under Inspector of School, Nalbari.
No, which school?
Gandia High School.
Gandia High School.
My lord.
The grievance of the petitioner that since February 2007 till date, the petitioner have not received any salary. It further reveals from the records that on 16th of March 2022, that on 6th of January 2022, it further reveals from the records that there are various interdepartmental communications regarding payment of the salary of the petitioner, payment of the area salary of the petitioner. There is no dispute that the petitioner is not entitled to the amount. However, it is in view of the indifferent attitude of the respondent authorities, more particularly the secondary education department, which have resulted in depriving the petitioner of the area salary since 2007. Under such circumstances, this court therefore directs the respondent authorities to take appropriate steps for releasing the present salary of the petitioner forthwith on the basis of a certified copy of the order being served upon the secondary education director of secondary education. As regards the area salary, the learned counsel appearing on behalf of the secondary education department shall apprise this court as to when the said amount shall be duly paid. It is also, this court further puts the officials of the secondary education department into notice that if there is a delay, if there is further delay in releasing the area salary, this court may also has also puts the petition, the officials of the secondary education department into notice and instruct them and notice, so that they to reply as to why interest should not be given to the petitioner for the delay caused in releasing his area salary, and why further the such interest should not be recovered from the salary of the hearing officials. List according. List on. We'll have it on 10th of May.
Highly obliged.
Obliged.
Yes.
May it please your lordship, the matter pertains to non-payment of arrears affidavit. As per law.
Lordship, as per our telephoning instructions, Lordship, a fresh step is being taken up for processing that arrear salary, and the director is issuing letter to the DEO, respective DEO, asking for the fresh proposal and also for the non-drawal certificate from the respective treasury officer. That process is being initiated. And otherwise also admittedly the petitioner is getting the current salary. So that he will get, the petitioner will get that salary. That fresh step is being initiated. Although there was a proposal from the DO.
How long you have not got?
From 1/1/2013 to 29 to
2013 to
2016.
2016.
16?
Yes.
Lots.
3 years?
3 years.
Very well. You're lucky enough. You saw the 1/1/2013 to 29 to 2016. Amount is 7,36,702.
Yes.
Okay. Mr. P. N. Sharma, the learned counsel appearing on behalf of the Elementary Education Department submits that the Director of Elementary Education has taken up the issue as regards the area salary of the petitioner for the period for the period from 1/1/2013 to 29/2/2016, and have directed the DPO, that is the Inspector of Schools,
No, District Elementary Education Officer. District Elementary Education Officer.
District Elementary Education Officer, to take to submit a fresh proposal, taking into account the same. Let this matter be again listed on 12th of May 2023, on which day the learned counsel for the Elementary Education Department shall apprise the court as to whether the area salary have been paid or not. This court further puts the Elementary Education officials of the Elementary Education Department into notice as to why interest should not be imposed upon the Elementary Education Department for the delay in payment of the area salary.
Okay.
Mr. Sharma, you know the consequence.
Lots of stuff.
Earlier case, I have said hearing officials.
Lots of-
Till now, I have not given. Next time, I'll do it.
Made feasible.
Yes.
In this, is that the respondent has filed an affidavit admitting the due retiral dues. of
You
the
have got how much? 1,26,000.
Lordship,
No, you got 12 lakh.
lordship.
There's one word missing. Anyway, how much you have got? 12 lakhs?
This is item 44, I think.
Huh?
Item 44. Item 44.
Isn't it 71997?
Lordship.
How much you have got out of 19 lakhs?
I have given it. I have already got 12,06,775.
12 lakhs 6,775.
75.
Accordingly, you are to receive another 7 lakh 3,000.
3,000.
Who is the department?
They have submitted an affidavit and they have admitted it.
Which department?
It is Urban Housing and Development.
Urban?
The Assam State Housing Board.
Oh,
The Urban Housing Board.
Assam State Housing Board doesn't work in this manner. Assam State Housing Board. Who is the lawyer? He go go.
But they are just a few minutes.
They don't work in this manner. Okay, we are still time, no? Heard Mr. M.H. Laskar, the learned counsel appearing on behalf of the petitioner. None appears on behalf of the respondent number 1 and 2 on call. It is apparent from the affidavit filed by the respondent number 1 and 2 that there is a clear-cut admission that the petitioner is entitled to an amount of rupees 7,03,608. This court, by the order dated 1/3/2023, had directed the learned counsel for the respondent number 1 and 2 to obtain instruction when the said amount will be paid to the petitioner on the next returnable date. However, none appears on behalf of the respondent number 1 and 2 today. Taking into account the same, this court fixes this matter again on 26th of April 2023. On the same date, the managing director of the Assam State Warehousing.
Commissioner, your lordship.
On the same date, the respondents shall file an affidavit stating their bank account, fixed deposits, if any, as well as their fixed assets, giving details of their bank account, comma, fixed deposits, comma, fixed assets, etc. They are giving, directing, they are saying that they are paying, they are going to pay in 12 installments.
12 installments.
You want it?
In piecemeal manner, it is difficult. In piecemeal manner, it is difficult for the petitioner. If they give it on 1 installment or 2 installment, that is okay. But in 12 installments,
Why?
you can use it for a purpose.
A copy of the instant order, certified copy of the instant order be served by the petitioner to the respondent number. To the respondent number, who? Two.
Apply the
Within 7 days from today.
apply.
Yes, Mr. Gogoi, you did not appear.
Lordship,
I've directed the managing director to appear
Lordship,
along with fixed assets and everything.
extremely sorry, Lord.
Well,
I was there, Lordship, just I came, got.
oh. Then what do you do? How do you pay?
Lordship, Lordship, I took photo, Lordship. Lordship, I filed a petition in opposition, Lordship.
I've seen it,
Lordship,
but then also you want to pay in 12 installments,
Lordship,
pay with interest. You want 12 installments, do it. We pay with 7%, it's the running. You compute it with 7% and on reducing balance, you pay.
Lordship. Lordship,
Everybody is paying. Earlier, state warehousing or in this matter, is Kanhailal Gupta is also appearing, na? In some matters?
Earlier.
Earlier? No, na? Not this matter.
No, not this.
Is he appearing for that corporation? No.
Earlier, there was several matters in other court, Lordship.
No, I passed in
Similar matter,
some
no?
other, what is that corporation? There is another corporation, they have the same problem. They were also asking for 12 things. Then I have directed to pay them with interest of 7% on reducing balance.
We are checking that monthly installment basis, Lordship.
No, you want installment, it's okay, but you pay with 7% interest. As on with 7% interest you pay on reducing balance in 12 months. How much it will be? It will only accrue from today. You are saying that 7,03,000 is there.
Lordship.
You add the 7% on reducing balance. Meaning thereby, if you pay 50,000 now, the next 50,000 will be, it will be on 6,50,000, the next 7%. But how do I otherwise order this when his entitlement is other? You end up, I think, paying around how much? 10,000-15,000 more, nothing more than that. That's it. How much does a person get interest in a year of 7 lakhs? At 7%? 49,000. 7%. So, but here it will be on reducing balance.
So can it be reduced?
We can increase, make it 10%. Because that is a uniform order.
Correct.
You want that?
There are similar order also there. I will be checked.
My code?
Our code also.
No,
There are
this code.
similar
No, every court has a different perspective. There are many orders also I can bring you where compound interest compounded has been given. You want that? We can give you that also. In many cases, there are 7% interest you've given. There are many percent, 12% interest. These are retirement benefits. One is a case of a gratuity. Gratuity, that is, you have to give under Section 7. You want 12%, you do it. Recompute it. And on reducing balance pay, you come to some 30,000. The benefit of. Yes, next matter. Take.
Lordship, condition is that, Lordship, our resource is very limited, Lordship. In compliance with the Honorable this court order, Lordship, we are paying every month more than 15 lakhs rupees as a connection with the retirement benefit.
Mr. Counsel, where is the question of compliance of this order, of this court's order? Are you not liable to pay on the basis that you have taken the employment?
Definitely.
Why you are making the court a party to your thing?
Lordship,
This court is only giving something which is they are entitled to. You have not deprived them from that. Then, in fact, is this court after he's entitled? You have admitted that he is entitled to that amount.
Admitted.
Then, under such circumstances, why this shouldn't be given to them? Don't blame the court for passing orders to that effect that you are to pay. You are otherwise liable to pay. What do you want?
What we will pay them 7%.
Argument. Administer to MH Loskor, the learned counsel appearing on behalf of the petitioner, Mr. T. Gogoi, the learned counsel appears on behalf of the respondent number 1 and 2. It is apparent from the records, more so from the affidavit in opposition filed by the respondent number 1 and 2, that the petitioner is entitled to an amount of rupees 7,03,608. This aspect of the matter can be seen from paragraph number 4 of the affidavit in opposition. It is, however, the case of the respondent number 1 and 2 that they are unable to make payment of the same. Immediately, and as such have requested for payment of the same in installments. In terms with paragraph number 6 of the affidavit in opposition, it transpires that the respondent number 1 and 2 have given an undertaking that they shall give an initial payment of rupees 1,03,608 on or before 2nd of April 2023 as the first installment, and the remaining 6 lakhs shall be paid in equal installments, monthly installments for 1 year, on or before 7th of each succeeding month. The learned counsel appearing on behalf of the petitioner have submitted that the amount so payable to the petitioner is long due. And the said amount of rupees 7,03,608 is a part of a gratuity amount. And in terms of the Payment of Gratuity Act, it is the mandate of law of Section 7 that there is a requirement for payment of interest. From the date the amount becomes payable. Upon hearing the learned counsel appearing on behalf of the parties taking into account the claims so made by the petitioner, had submitted that a consensus has been arrived at which is based upon instructions. That if the amount of rupees 7,03,608 is paid along with interest at 7% on reducing balance from the date of the instant order in equal installments, in 12 equal installments, starting from the month of April 2023 and ending on 31st of March 2024. The petitioner shall have no objection. Taking into account the said submission, the instant petitions therefore stands disposed of with a direction to the respondent number 1 and 2 to pay the amount of rupees 7,03,000 to pay the amount of rupees 7,03,608 along with interest at the rate of 7% from the date of the instant order on reducing balance to the petitioner in 12 equal installments starting from the month of April 2023 till the entire amount has to be liquidated by the respondent number 1 and 2 by 31st of March 2024. With the above, the petition stands disposed.
The amount may be deposited in the account of the petitioner, otherwise she has to come every time to the Guwahati.
The petitioner, do they have the account?
No, we'll furnish.
No.
The learning counsel for the petitioner submits that within 3 days from today, the petitioner shall submit the details of their account, of his account, his or her account, to the respondent number 2 by 27th of March to 29th of March 2023.
And the amount to be paid in the bank account. The amount is to be paid into the account here.
And the said amount as above directed shall be paid to the account of the petitioner.
I'm developer.
Yes, Mr. Nayak.
My instructions are divided, Lordship. Yesterday also I forwarded one reminder, Lordship. In this case, his claim for arrear salary has been rejected by the authority.
Rejected?
Yes. No. Earlier rejected, Lordship. Against that rejection order, he has filed his present petition.
Why it was rejected? Where?
Page 22, Lord.
This is the input order, madam.
No reason is given there.
Page 22,
Lord.
That is under challenge, madam.
With reference to that, it is to inform you that on the basis of the report of the student, in other than your prayer petition for the area salary is summarily rejected. Then what happened? Oh,
The earlier petition was withdrawn. Now against the rejection order, the present petition has been filed. I have.
you do one thing, you take your instructions.
Lord.
We'll have it on 8th of May.
Lord.
You file your, if you want to oppose it, file your affidavit.
Lord.
Or Mr. S. Nath, the learned counsel for the petitioner, and Mr. P. Nayak, the learned counsel appearing on behalf of the 2, 3, 4, and 5, 6. Mr. S.R. Bolu appears for respondent number 7, and Mr. P. N. Sharma appears for 1 and 5. The learned counsel for the respondent submits that they need an accommodation to get the instructions in the matter, and they further submit that they would file their affidavit in the circumstance. The instructions, and in that regard, they submit that they would file their affidavit on or before the next date. Placed the matter on 10th of May 2023, on which, on or before which date the petition and respondent shall file their affidavit. Huh?
Yeah,
Mr. Nath,
I already served my lord on,
whom have you served?
that's up to the office of the airport.
I had only one copy, Lordship, that I have forwarded to the extra copy.
Again, last occasion I already served.
Yes.
Lordship, there is an instruction, Lordship.
Ah.
The proposal has been sent to the government for according sanction. I mean,
So you have requested for the sanction.
Lordship.
How much time?
Lordship, once the sanction is received from the government.
No, no,
it
no,
will
no,
take
no.
some time.
Sanction doesn't happen so.
Because
This aspect, nah, this will go into the.
otherwise also this sanction will be accorded in the next budget session, Lordship. It will take some time.
We'll have it after 2 months.
Lordship.
Miss
S. Gupta.
S.N. Gupta, the learned counsel appearing on behalf of petition. Mr. P.N. Sharma appears on behalf of the School Education Department. He has drawn the attention of this court that the Director of Elementary Education, Assam, had written in communication on 18th of March 2023 to the Secretary to the Government of Assam, Department of School Education, requesting for according of the sanction for the amount of rupees 13,03,054 to be paid to the petitioner. The said communication so issued by the Director of Elementary Education, Assam, is kept on record and marked with the letter X. So Mr. P.N. Sharma, the learned counsel appearing on behalf of the school education, submits that as the budget is not over. Budget is over.
But budget is over now. Now
Then-
the sanction will be accorded.
Submits that taking into account that the budget is over, necessary sanction is most likely to be given in pursuant to the state communication. He submits that let the matter be listed again on 8th of May 2025 on 23, on which date the petition, the respondent in the school education department shall apprise this court as regards the status of for disbursement of the amount of rupees 13,63,054 to the petition.
Obliged.
Obliged.
Yes.
The matter pertains to suspension of the petition and I'm praying for his reinstatement matter.
What?
Matter pertains to suspension of the petitioner from service under Rule 6(2), my lord, of the Assam Civil Service Discipline and Appeal Rule. And we are praying for his reinstatement.
Oh, this one.
Yes, sir. Last question is instruction is sought for.
Ah.
Today I have to file an affidavit.
You want to file an affidavit?
No, they have filed.
Already filed. It's
Yes,
on
what is
record.
it? What do you want to say?
Communication with the 12/12/2020 was received by the department on 17/12.
Ah.
17/12/2020.
Therefore,
And
on
next
9th,
instruction
another
was
letter
for
was
for
sent
whether
to the
charge sheet has been filed or not. Charge sheet
requesting-
has already been filed.
You have given memorandum of
Yes,
charge.
Lordship. Yes, 17th it was issued.
Where is the copy?
On
It
paper,
is not,
given,
right now, this is not with me. Lordship.
Why haven't you given it?
no issuing number also in para 7.
Lordship, I have, Lordship.
Huh?
Yes, Lordship, extra copy I have, Lordship. Yes,
You have it?
yes.
And my lord, the Lordship has seen, we have issued the letter on, informed the authority why our letter, registered post letter on 12/12. They have received in, admittedly, they have received on 17th.
Yeah.
And as per the track record of the procedure, they have received on 16th. Anyway, my lord, I'm not going to that. No, my lord, that letter, so-called notice has been issued on 17th, but we have not received it till yet, my lord, and there is no issue number, they have not annexed it with the
You take it.
No, my lord, I'm not going to take it. It's a personal litigation.
Mr. Patwari, I make it very clear one thing.
Right.
The basis of Ajay Chaudhary is an early disposal of the departmental proceedings. Now, if they want to serve you and you don't receive it,
No.
it goes beyond the effect of Ajay
I
Chaudhary.
will receive it, my lord, but they have stated,
Okay, you
made
receive
a
it.
clerical statement that they have issued a so-called notice on 17th, which I have not received, my lord, till date. They have not received a issuing number. also.
Today is 24th, Lordship.
Yes, today is
They required
24.
on
I have
time.
not received it, my lord.
It
I
is
have
as
clear
well.
instruction by my client. They have not annexed it with the affidavit also, my lord.
Now-
Annexed
now-
with their affidavit.
Hello.
Now over the board, they are
Lordship,
giving,
just
my
maybe
lord.
kept a record.
No, my
Lordship.
lord, in my humble submission, 90 days is over, my lord.
No. Mr. Patwari, this does not gel with me one, because this court also has to take note of paragraph 22.
Yes, Lordship.
Once this is done, the matter becomes infructuous on that Ajay Chaudhary. And thereafter, it can again arise. We can have it after another 6 months. We can keep the matter pending
No,
for
6
review.
months, my lord, that is an executive instruction, my lord. Other should prevail. And
Ajay
lordship-
Chaudhary, does it say 90 days for review?
No, review no, matter for child submission of memorandum of charge. The first part says 90 days for submission of memorandum of charges.
Thereafter, what do you say about paragraph 22?
Thereafter, if memorandum is served within 90 days, then my lord, they have to extend the suspension order by passing a speeding order.
No, it doesn't say if it is served within 90 days. No. It says if the memorandum of charges is served, then also they have to review. That is the word. There is no within 90 days. in the second. How did you send it?
Lordship, by post, Lordship.
Does he have an email? We are modernizing everything nowadays.
Email not.
Are we not asking for the petitioner's email here?
The case was listed on 17th. The document is also purportedly issued on 17th, my lord.
Why? Because he has received it on 17/3/12.
Exactly,
No,
my
but
lord.
then
No
also.
no issuing number in the affidavit.
Hmm?
But
Yes,
you
why
can
haven't
see
you
para
filed
7
it?
of the
No, no.
affidavit.
But all said and done. You may say something else, but you see, this is digitally signed on 70. So once it is digitally signed, you can't alter it. You see, any other backdated you can do, but once it is digitally signed, you can't do anything. The time, everything comes.
True, my lord. I am not saying that it's antedated, but this honorable court was in session of the matter. on
Okay,
17th, but
Mr. Datta, you place this on record by way of an affidavit.
Okay, Lordship. Yes.
Have you mentioned that you have given?
Yes, para 7 of the
Pass of
affidavit.
number.
Page 45.
Oh, on 17, so-called notice charge sheet along with the statement of education, list of witnesses, as well as the has been already. Heard Mr. J. Patwari, the learned counsel appearing on behalf of petitioner, and Mr. S. Datta, the learned counsel appearing on behalf of the responsible. Today, an affidavit has been filed by the respondent number 2 and 3. To the Joint Secretary to the Government of Assam Revenue and Disaster Management Department. In paragraph number 7 of the said affidavit, it has been mentioned that the show cause notice, record charge sheet, along with the statement of allegation from a list of witnesses and the list of documents have already been issued to the petitioner. However, here, no, Mr. S. Datta, during the course of the hearing, brought to the notice of this court the show cause notice. This court finds it appropriate that the state show cause notice be put by on record by way of an affidavit. That the matter be again listed on 10th of April. The affidavit be filed by 3rd of April. 3rd of April. And the petitioner is at liberty to file that such additional affidavit be filed by the respondents by 3rd of April, and the petitioner would be at liberty to file their objection, if any, their reply, if any, by 10th of April. Or should we have it on 7th is close? No time.
Obliged.
My lord, in this case, my lord, the petitioner, my lord, has prayed for release of his area retirement benefits, my lord, and also for appointment of an auditor for the case difference, my lord. Now, my lord, the affidavit which were submitted earlier, my lord, covers this second relief, my lord, regarding the case difference, my lord. But our position regarding why his retirement benefits have been withheld, my lord, is not clear from the earlier affidavit, my lord. So we'd like to file an additional affidavit on this, my lord.
Your name?
S. Das, my lord.
Mr. S. Das, the learned counsel appearing on behalf of?
My lord, 226, my lord.
Respondent number 2 to 6 submit that he would like to file an additional affidavit bringing on record as to why the retirement benefit
yes, my lord,
have not been paid.
Yes, my lord, has been withheld, my lord.
Have been withheld.
Yes.
Let the matter be again listed on 11th of April 2023. The learned counsel appearing on behalf of the respondent number 226. 226?
Yes, my lord, 326, my lord, 326.
326. Is either directed, it is directed either to may file the affidavit, may file the additional affidavit on or before 10th of April 2023. That shall file the affidavit, additional affidavit on or before list according.
Much obliged. Wait,
yes.
Lordship kindly peruses the last order, the order dated 22/2/2023. The last paragraph, the respondents were directed to apprise this honorable court as to why the petitioner has not been paid 50% of the pension as directed by this honorable court in the order as referred above.
Where?
Or last order, my lord, 22/2/2023, my lord.
The
Last
grievance of the petitioner is that in pursuance to the order dated so and so in WPC number so and so, the petitioner had not been paid 50% of the pension as directed. Yes, we got some instruction. Fine. They are making allegations upon you. You have not been able to, they have not been able to comply because of you. You have made the treasury officer party?
Yes, my lord. Respondent number 7, my lord.
11. 11.
11, madam.
In the meantime, you direct the treasury officer
Yes, madam.
to send it.
Madam.
I'm only putting a push.
Yes, madam.
There's no, otherwise there's no legal anything out there. They are saying that they want to comply, but the both have are not being sent by the treasury. Isn't it? So the treasury also doesn't look, it is the pension who will look into it, isn't it?
I will take a scan copy and I will transfer to the treasury.
Mr. Heard Mr. A.K. Bolwar, the learned counsel appearing on behalf of the petitioner. And
And for
Mr.
respect number
S.R. Bolwar appears
128.
on behalf of the Directorate of Pension. And Mr. R. Bopuzari appears on behalf of the respondent number of the Finance Department as well as the Treasury Officer. The Director of Pension by the communication to the Treasury Officer Tihu on 31/10/2022 had requested to return both half of the PPO number PPO/PPO/E/2981 in respect to the husband of the petitioner, husband of the petitioner, along with the date payment certificate for taking necessary action. Today, Mr. S.R. Bolwar, the learned counsel, have drawn the attention to a communication instruction issued by the Director of Pension, wherein it has been mentioned that in view of the fact that the Treasury Officer who have not returned both half, steps could not be taken in terms with the directions passed by this court in its order dated 3/10/2019 passed in WPC number 2161/2018. The said instructions were placed by Mr. S.R. Bolwar is kept on record and marked with the letter X. Let the matter be listed again on 11th of April 2023, on which day the learned counsel, Mr. R. Bopuzari, shall apprise this court as to whether the Treasury Officer have sent the both the half of PPO number PPO/E/2981 to the Director of Pension Assam, Mr. S.R. Bolwar, shall also apprise this court as regards the further steps so taken.
Deeply.
Non-payment of pension of the benefit to the petitioner.
Oh,
That is the
you
case.
mentioned listed. Yes, what happened? This
May I
one?
please, Rosie?
Ah.
Rosie, Mr. A. Hassan supposed to appear today in this
Who?
matter, Rosie. Mr. A. Hassan.
Where is he?
But due to
supposed to appear, but because he's
Because of-
fasting, he's fasting,
Yes,
so
already
he is
left.
scared to leave. That's what.
can the matter be taken up next week? Okay, can I get-
What is the matter about?
My lord, the petitioner, my lord, retired on 39/2017. As Amin, my lord, he was an office, official in the, my lord, DC establishment, the district reporting with, my lord. And he is now, my lord, receiving his provisional pension. But the final pension has not been released till date, my lord. On the earlier occasion, my lord, he had instructions.
You are asking for final pension and gratuity.
My lord, 3% additional increment, my lord, which was given by a
Oh.
notification in 2018, my lord, with effect of 1/1/2016. Now, but my lord, that matter has already been solved, my lord, by a decision of the cabinet. Pension along with 3% additional increment.
But why you are asking from backdated? It has only been brought only by 21/12/2022.
But in continuation of earlier notification.
We'll have it on when Mr. Hassan is there. When?
Next week, any day.
Week, no time, only next week. What is this next week?
On the last
How many
occasion,
dates are there?
on the last occasion, he was present with the instructions.
We'll have it on 3rd. Leaves the matter. Tomorrow is closed. On 3rd of April 2023 at 2 p.m.
Clear on first. Unnecessary.
Yes, any urgent matters? Oh, Mr. Gupta, sorry. I saw you from the morning. Which matter you are waiting for?
Well, item number 22 here.
Show me that. 22.
In this case, the petitioner was serving as a honorary teacher in a school. In the year, she was appointed in the year 75, and she attained her age of superannuation in the year 2012. So she, throughout her service life, she had not received anything. Throughout her service life, she had not received anything. So
She has not received anything.
anything. Because now, she filed an application for grant of some pension. Now, in the last occasion, on 19/9/2022, PTC was implemented as a party respondent, respondent number 7. If they can file an affidavit, that will be.
Then but you have not been regularized.
No,
Then how can you get pension?
that is what I'm trying for. To have, because Lord, I have spent my entire life.
But difficulties arise, no?
Yes, sir, definitely it's a hard.
What difficulties means?
Definitely hard.
See,
Sir,
Mr.
hard, sir.
Dasgupta,
Well, I would
problem
like
is
to,
this.
I would like to place my case. I shall try and best to pursue the directive principle. This much as I can do and nothing else. My client is pressing me hard. I know my case is not very easy.
And more particularly, the problem which arises is unless you are not regularized or you are not a regular employee in terms of wage. So let us not finish the day with a bad thing. But I'm sorry, I kept you waiting for this.
No problem, no problem. You also can kindly pick any date.
Yes, affidavit you are filing.
Lordship, today only I came to know, and after going through the records collected from my friend, Lordship, not regularized, that too after provincialization, she was appointed on
No,
my
that is
basis.
admitted position.
It's an admitted position. Lordship.
Huh?
Admitted position. Lordship.
Chalo, we'll have it on another date. But a very difficult case.
Definitely, I know very. Without any affidavit, it can be done.
And what happens, the problem is not that. Problem is any order passed in these has the tendency of being misused in other cases. That is the worst thing which can happen.
I am not
Means
I am not very hopeful that I will get a positive order.
Hello.
That I know my limitation.
Let the matter be listed again. When do you want it?
Any day.
After in May, month of May? April there is no date. We'll have
Any
it
lordship, particular lordship
Lord
convenience.
Mr. A. Dasgupta, the learned counsel, senior counsel, assisted by himself, and Mr. B. Chaudhary, appearing on behalf of,
Respondent number 7,
what is that?
BTC, Lordship. A Director of Education.
BTC. BTC.
Later in period.
And Mr. S.R. Borua for the government. Which school? Any
Right.
school education department? Mr. Sharma is appearing for elementary. What business you have? Okay. Appears on behalf of the elementary education department. The learned counsel for the respondent submits that in the facts, the respondents are not inclined to file any affidavit, but they shall contest, they'll make submissions on the basis of law.
Yes.
Taking into account, let the matter be listed on 10th of May 2023.
My lord, I am appearing